Yes, Mr. Chandra.
May the Lordship, my lord, I am sorry to mention one item, my lord, because I will be stuck in court number 2 today, my lord. Only accommodation for the day. Next Tuesday, I will do it, my lord. Item number 20. I have taken consent from the other side. I will do it next day, but I have been newly engaged over in this case also.
Last occasion also you have taken time.
My lord, I will do it on next Tuesday, definitely.
13 matters, Mr.
30th, on 30th, my lord, definitely I will do it, my lord. No other chance. 30th is a Tuesday, my lord.
On the prayer made by Mr. P.K. Chaudhary, on a council, right, Chaudhary, on a council for disciplinary. There's this matter again on 1/2/2024.
Well,
No further adjournments shall be granted in the matter.
obliged.
Mayor, please. Listing of IA, your lordship.
Any listing matters, please give it to him. If you want it today, then only make a mention. Psychiatry development.
The month of February. Your lordship, for tomorrow, your lordship. Wait to him.
My lord,
Other than today, please don't make a mention. Give it to him.
Lord, I request some accommodation for today, lordship. If I am unwell today, let the matter come up next week.
Item
26. Okay, where?
on the prayer made by Mr. A. Ganguly. List this matter again on 12/2/2024.
Item number?
26.
Yes, lordship.
May I please your lordship?
Hmm.
I beg to mention item number 39 on behalf of M. Bhagavati. He has some medical emergency.
On a prayer made on behalf of Mr. M. Bhagavati, who is stated to M. Bhagavati, list this matter again
39.
on Contempt matter. We'll have it on 7th.
May it please your lordship. Lordship, item number 37, Lord.
30?
37.
Hmm.
Lord, here we have filed a contempt. Lord, there is a non-compliance of the order passed by the Honorable Court.
Hmm.
Lord, in that matter, my lord, notice has already been issued.
Hmm.
May I pray, my lord, day after tomorrow, the matter may be taken on along with that contempt petition.
Day after tomorrow, it may not be possible.
Lordship, I have some certain objection in this case, lordship.
We'll accommodate you, no problem. Huh? Yes, Mr.
I have some objection with respect to item number 37.
Hmm.
Lordship, till date, we have not received any notice. That is independent. Lordship may decide contempt separately.
He is making
And
a mention prayer. We
Lordship,
will have the contempt. And we've
Recruitment
taken
has
this
been
matter
stalled,
on
lordship.
5th.
Fifth.
On the prayer made by Mr. H. Betala, list this matter again on 5/2/2024. We'll have it on 5th.
My lord,
We'll not adjourn it again.
Lord, that contempt may come along with that.
No. Let the contempt come.
That is a different thing, lordship.
different thing. altogether.
May I
Hello.
please, your lordship? In item number 17, also, we have filed an affidavit in reply that may be called for.
Item number?
17. That may be called for to the record.
Okay.
Obliged.
May I please, my lord?
It's that oil India matter. Call.
Well, I beg to mention item number 31. Here in this case, lordship is directed to produce some instruction, my lord. On the failing on the part of learned counsel to produce the relevant record, instruction of next day fix necessary order, including personal appearance of the department officer will be passed. My lord, here I need some accommodation due to.
Let the matter be called. Let the matter be called.
Obliged.
Yeah, matter. Delivery of order to ek number to
Daily list, item number 1 for delivery of order.
move pension manual to or discipline appeal rules to.
One lordship, last occasion my brother is appeared lordship. As because file is not our hand, we have taken the second file from court today also lordship. So we have clarified to something lordship. If lordship wants to hear it lordship, we can place our case lordship. Question now.
I've recorded in my order that I'll hear you. I've
Lordship,
heard Mr. Bachchaji.
lordship. We have no objection. First, my senior sir will advance, then.
Mr. Bachchaji, one factor. Just give me the date of retirement.
Your lordship would kindly give me some time. I want to point out.
Lordship.
I have two pronouns. And both the things I am assertively saying that first point that there was no inquiry. Then Miller, this that I failed to point out. He says, that if the disciplinary authority goes for disciplinary petitioning, then you will be given a chance to represent or to examine your represent. So in my last argument, I said that there was no inquiry, no. Now, my lord, if my first argument is accepted by your lordship, in that case, my lord, till I submitted application for voluntary retirement, I am deemed to have been insolvent.
You
In
mean to
that
say
case-
voluntary retirement not accepted, you are deemed to be in service.
In that case, my lord, if your lordship holds that a dismissal order is bad and there is no inquiry. Why it is bad, that your lordship will definitely say that is the only point I said there is no inquiry under the rules. In that case, my lord, I will be entitled to back wages and I would be retiring next year.
You have not retired till now.
No, next year.
That day I was given the impression that you had retired.
No, next year. There,
Date of superannuation is next.
Huh?
My date of superannuation is next year.
Okay, that day I got the impression that you had already retired.
your lordship is right, because what happened?
Yeah,
That he gave me an impression. That's why I formulated the questions in that manner.
For the
Well, we contacted.
That's why today I had a doubt. That's why the first question I asked when you retired. Okay, you have not retired till now.
There is little difficulty in that sense, because this information we got from the husband of the petitioner. Both of them are engineers, both of them are professors. But anyway, my lord, if your lordship wants to confirm that, government advocate can say that that is my information by the client, that she will be retiring next year.
Fine, I take it. I take it.
In that case, my lord, I am entitled to back wages till the filing of the application for voluntary retirement. But, my lord, there when you lordship will consider that 14 months will be excluded. I will not get in, because the lordship will find that it was not regularized. And that is why they given one statement of allegation. So that for 14 months will be,
Which is the period?
There are two extraordinary leave periods which were not
Huh.
sanctioned.
who counted it will be 14 months.
The first period is from 1st of August 2006 till 31st of October 2006.
Okay, you can give me, I'll take it from you. You can give me a small note on that.
So that goes below. Because my both the arguments is available to me. Suppose your lordship goes for that she is retiring next year. Your lordship will dispose of the application form. In that case, my lord, since consent is not necessary, then my lord, the day I have applied for voluntary retirement, it is deemed to have been accepted. And in that case, my lord, the departmental proceeding, on that day I was not a public servant.
Mr. Pachaji, can I just interrupt? Can you have the voluntary retirement application once?
Application,
Application. My God.
70.
page 70.
Yes.
he has calculated it. Your Lordship got it.
Sir, if you can just come to page 71.
71. Next one.
71,
Yes, madam.
the last paragraph. If it was your categorical case that I am voluntarily retiring, say not 3 months from today onwards, it would have been a different ballgame altogether. Here the prayer is, therefore, grant me voluntary retirement on a date which the government will fix. In that view of the matter, what would be the effect of this application and this paragraph, according to you?
If the law is known, I need not request the
We can have that FRSR from it.
56, under 56
C.
C.
See. FRS.
May I read it? Any government servant,
This is it.
any government servant may,
By
by giving notice of not less than 3 months in writing to the appropriate authority, retire from service after he has attained the age of 50 years or has completed 25 years of service, whether it is, whichever is earlier.
So you completed 50 years on which date?
I completed 23, 25 years to by notification, 20 years to.
Lord, this 25 years
Hmm.
by gazette notification is reduced to 20 years. That notification. Your
That
Lordship,
after that fifth pay commission, I suppose. Yes. You had completed 20 years of
Your
service.
Lordship may kindly please. This is the notification.
What is the date of our initial entry into service?
Initial
Initial entry?
entry,
Huh?
83.
83.
83. 13/9/1983.
Clause number 1. A government servant may be given notice of not less than 3 months in writing to the appropriate authority, retire from service at any time after he has attained the age of 50 years of, or after he has completed 20 years of qualifying service. It is much clearer now. Two alternatives are given. Why I am saying, my lord, that
Good.
that 14 months should be excluded because that
No,
principle.
Mr. Bachchaji, I have a doubt with regard to your last paragraph. In this wording, how do you determine that date,
Determine.
the date from where you will retire? Should I deem it to be 3 months from this letter, 14/9/2007?
Because consent is not necessary.
Hmm.
The moment I give it, 3 months is given to the petitioner, he qualifies. Not that within 3 months they will accept. They accept, that is extra. But I am entitled, the word is voluntary return. And these two Supreme Court decisions are there.
You have placed on the last. And this inquiry thing, preliminary inquiry, occasion sometime in corresponding to the period when you had submitted your application.
During the period of
During that period of 3 months, this occasion.
That in a letter itself is explained.
Now, Mr. Bachchaji, if a person is submitting an application for, forget your case, this case, and that against that person there is some grave allegations, some serious allegations. I'm not with your case. In that view of the matter, can't the government stop that, prevent that man from
Now,
doing
in
away?
that case, government has to inform me that we are contemplating disciplinary process. So we are not accepting it. Then she may come to the court
Asking for a,
asking for that. But according to me, that will be a little unfair for the government. So he may be involved in a murder case. He may be involved in a
he may have defalcated a huge amount, misappropriated a huge amount.
so in that case, you can't sit like that is in your mind. I must know. I may not have, or I could have withdrawn. If you sit that the law is no consent is necessary, the government, but still there may be case in between. In that case, I will not submit that government is absolutely powerless. Now, your lordship will see, the other day your lordship has pointed out that they are contemplating departmental proceeding. That has come in the order of the governor. Appellate. Your lordship will kindly see that.
It's 127.
Page 120.
128.
127.
Orders of the governor, notification.
Appeal.
Yes, that is 128, appellate order.
Appellate.
128.
128.
Because, my lord, when your lordship pointed out, said that your lordship got it somewhere. So that I have to meet. After careful examination of the appeals and materials on record, it is found that the application dated so and so submitted by Dr. Sukuntala Aswar praying for voluntary retirement was duly considered by government, but did not agree to it as there was a contemplation of the government for trial of departmental proceedings against her at that point of time. This letter.
This is what I was pointing out. Okay.
But how he comes to know about it? Whether at all that the government has considered it. What is the record?
Yes, Mr. Bachchaji.
Now your lordship will see that materials on record. It is found that application so and so submitted by so and so was duly considered by the government. What is that? It's a peculiar thing, my lord, that they will not file affidavit. They will not show anything. Let them show a word which I have.
No, that's what I wanted to ask Mr. Das on the last occasion. From where they are, because this when I was going through the brief, I got hold of this. So if this is the stand, okay, they did not communicate to you. Fine, we'll excuse them for that. But if they had undertaken an exercise to that extent,
Yes.
then that is something different.
I have never seen that service matters are being argued without the record.
Can't help it.
What is your lordship's position? Definitely-
I'm in a country now. How can I, on oral submissions, go ahead and make my decision?
And this is a matter of livelihood,
Yes. And this is a matter of 2013.
absolute silent.
It gives an
I
impression
I have my grave doubt whether they have brought a copy of the application.
that's their headache.
After 12 years, it has come. These 12 years, they were sleeping. Government changes. And it's not a matter of joke, my lord. She was an IIT product, and at the same time, my lord, she has opened up new instrumentation engineering.
Course in that. And the students had put in an application, don't take her away. We want her for that time.
So, in
These
the
things
heart
are-
of the heart, my lord, what was there in the mind? True, my lord, they can say that husband and wife both are staying at Guwahati as officials.
Mr.
So,
Bachchaji, this
why
is-
I have said, my lord, that 14 months should be enough.
that I got it. EOL period, because you have not worked for that.
No work, no ways on that principle. I have said.
When I had first subject, till that time, the retirement issue had not come up. My view was that this order at page 103, subject to what Mr. Gogoi would say, is per se illegal. Prima facie. Because even if they have accepted your stance as admission, they could not have relied on the preliminary inquiry report
Yes.
to come to this conclusion. To that extent, this is wrong.
According to me, it is a mere administrative inquiry.
Then
not
I
in-
was
inquiry under
contemplating
two.
that whether we can accept your VRS and then excluding that period of EUL, direct them to have your qualifying service taken till the date you rejoin after the first earn leave episode. But on the last occasion, when I was told that she had already retired in 2007 and thereafter this show cause was issued, the whole the facet changed.
Yes.
Because naturally, you are no longer a government servant and the proceedings cannot be under the 64 rules. It has to go to the pension rules. Now that you have told me that they are not there, so we go back to the first position. Now, Mr. Bachchaji, another aspect, I just want a clarification, something troubling me. I hold that this page 103 and the appellate order to be not sustainable. You are still in service. You have, because of this, you are not there, but moment I interfere it, you will come back to service. Can't a direction be issued to them within a time frame to complete this inquiry against you? Complete this inquiry against you.
Too much, very harsh. Because
I just want a
no,
clarification.
your lordship will say, let me point out this. Except the show cause notice, which is in terms of 64 rules. Thereafter, they stop.
No, they have apparently done nothing.
And moreover, my lord, see the history of the case. I am before your lordship after 12 years. Whom your lordship is going to hold responsible. High Court is equally responsible. Secondly, my lord, even today, one day they got that they could have brought a record or filed an affidavit. I do not object to that.
Okay.
Let me be there with according to law. That's why I said that 14 months your lordship will.
No, that will otherwise also go. Because that is no work, no pay, we will hold.
Yes. So,
Anything
my lord,
more,
my last submission in support of the first argument, that I will be entitled to the back wage till the date of filing the voluntary retirement. Minus those 14 months leave without approval. But for the voluntary retirement, I would have asked the entire backwards.
And voluntary retirement, according to you, from the date you have submitted an application, 3 months.
3 months.
And your further submission is that mere a preliminary inquiry cannot stall you
No, I
because
say it is an
they had not communicated that to you.
administrative, but I will not call it preliminary. Preliminary, they have the jurisdiction to go for it, you know.
They have practically gone for a preliminary. We'll have to deem it that Manzoor Hussein's inquiry to be a preliminary inquiry only. That is because the document is annexed at page 98. If you can just come.
No, that will not prejudice me, even if your lordship holds it a preliminary. That does not prejudice me at all.
And that report was given on 23/10/2007. And the proceedings came to be initiated in 2009.
Yes, after 2 years.
Yes. Got it.
Am I clear, madam?
Yes. Yes, Mr. Gogoi.
First of all, Lordship, on what point I have to argue? They have advanced 2 points, Lordship. One in respect of voluntary
You will
retirement,
have to argue in both.
both points. Then, Lordship, first of all, I argue in the first point, Lordship, regarding voluntary retirement.
And Mr. Gogoi,
Lordship,
when you are arguing on the first point,
Lordship,
take note of page 128.
128, Lordship. Lordship, I already marked it, Lordship.
So I will require a reply to this
Lordship,
also.
Lordship.
Yes.
Yes, to
128. That's that appellate authority.
Lordship, Lordship. Page 70, Lordship. First of all, Lordship, voluntary retirement. Application for voluntary retirement. It is admitted that, Lordship, in the last paragraph, Lordship, I joined my service as lecturer on 10th October 1983 at Juhat Engineering College. As such, I have completed more than 23 years of my service. Whether this application on 14 September 2007 is acceptable as a valid document for the purpose of voluntary retirement, Lordship have to decide, Lordship. As because, Lordship, 7C says, I have also, Lordship, placed that 7C was already omitted, Lordship.
No.
By subsequent.
no.
It is there, Lordship. I have the books, I have placed it.
Huh?
It is there, Lordship.
Which one?
It is Dewan books, my senior science referred Dewan books. FRS probably. Dewan books. And I also placed the latest publication of Dewan books, Lordship, same publishers, Lordship. Same publishers. And even Orient publication also, Lordship.
Even my book says.
There is a confusion, even, Lordship, that issue was also raised before the Honorable Court number 17 also, Lordship. It's a publisher of Skyline Forecast, Lordship. So Dewan from origin. And all books, my Lord, may kindly take. Just I point out these things.
No. You are at liberty to point out whatever you want.
All books says that, Lordship, in 56. C, Lordship.
C is deleted.
C is omitted, Lordship. C is omitted, subsequent notification, Lordship may kindly tell the notification, I have not the books at present, Lordship. Both the books before, Lordship.
I think there is some prescription in that Fifth Pay Commission report. Have you got it, Mr. Doctor? Fifth Pay Commission had made some because it reduced that 20 years in case of pension to 10 years. And I think this was also reduced. Because if it is 1/1/2006 fifth pay, you will be covered.
And Lordship,
Yes.
that part Lordship may kindly pause. That is omitted, Lordship. That is omitted, Lordship, before submission of the application, Lordship. That part. And otherwise also, Lordship, the OM which was present, Lordship. This OM cannot override the Lordship, the law enacted under Lordship. This is a fundamental rules made by the Governor of Assam under section 241 2B of the Governance of India Act 1935, Lordship. It's a fundamental rules, although it was, Lordship, that 1935 rules was already, Lordship. And when my Lord may kindly peruse all the books, Lordship. It is written as, Lordship, made by the Governor of Assam under section 241.
No, there is no doubt of the source of FRSR.
If that source is there, Lordship, how Government of Assam by way of office memorandum that 1984 it can be reduced to 20 years, Lordship? It cannot be, Lordship. It cannot be, Lordship. Otherwise also, Lordship, amendment is, Lordship, after 1984.
You come to that notification and you will find this in all notifications, Mr. Gogoi.
Lordship, I have.
No. You will find this in all notifications that whenever an incorporation is made in the FRSR, it is made in this form.
Lordship, that's why, Lordship, the last amendment is there, Lordship. The latest amendment is there in the books, Lordship.
Not on that. It's been deleted.
Lordship.
Get me this this notification, 98.
Lordship.
98 notification. But I have my serious doubts. So there is a
Otherwise
retirement,
also,
voluntary retirement is permissible.
voluntary retirement permissible, Lordship, subject to fulfillment of the condition of the Lordship. Earlier, it was as per the Supreme Court judgment 7C, Lordship. For fulfillment of 7C, Lordship, it should be, Lordship, 50 years or 25 years of service, Lordship.
No, your book C is totally deleted. Now, whereas C provision now been reincorporated.
Now been KL, Lordship. KL, probably KL, Lordship. KL or something, Lordship.
Wait, just a moment.
It was, Lordship, marked in the book, Lordship. Probably KL, Lordship. But that cap is not there. 50 years and 55 years cap is there, Lordship. The service period is not there in KL, new amendment, Lordship.
It's here. It come to K1.
K1, Lordship, it's a 50 years or 55 years. If Lordship, the particular person is joined the service before attaining the age of 35 years, then it should be 50 years. And after 35 years, Lordship, then it should be 55 years, Lordship.
Any government service may by giving notice of not less than 3 months in writing to the appropriate retire from service after he has attained the age of 50 years. If he is in Group A or Group B service or post and had entered in government service before attaining the age of 35 years, and in all other cases after he has attained the age of 55 years.
Lordship. Only that prescription is there, Lordship. And others are similar regarding, Lordship. When
What
it
is
can
the
be,
date of birth of your
what can it be?
of the petitioner? Date of birth of the petitioner?
Affidavit says that it is 52 years as on, Lordship, 2012.
No, that affidavit may not be very.
Lordship.
The exact date of birth I will have to take instead.
Just have a call. We can just have it. So that may be relevant.
When she is, Lordship, appointed before 35 years, then it should be 50 years, Lordship. In 2007, Lordship, it cannot be 50 years, Lordship. If 2012, Lordship, the petitioner's age is 52 years,
I got your point.
then it cannot be 50 years, Lordship. So as per the statutory prescription, Lordship, the application which was submitted for a voluntary retirement cannot be considered as a valid document, and the authority is not bound to act upon this document, Lordship.
Then why have you written in your page 128?
They have done something. They have done something, but the executive order.
Okay.
Pass the executive order, Lordship cannot override the statutory provision.
Okay.
And my lord it is sitting in a constitutional court, Lordship.
Subject to examination of this and also hearing Mr. Bachchaji on
Yes.
this. You come to your second point.
Lordship,
This I got it.
Lordship.
Come to the
Second
second.
point also, Lordship, for immediate performance. So, my lord, may come to page 95, Lordship. It says show cause, Lordship. Show cause was issued. Mention public orders. Reply to question. No, I will reply. I will need to reply to question. Second question. Statement.
ROP rules 2010. Yeah.
Please. My lord, may kindly come to page 78. The statement recorded by the petitioner himself before the inquiry committee, Lordship.
1 second. 1
Page
second.
78.
1 second. 1 second.
Petitioner.
Okay. Yes. You are at which page?
My lord, may kindly come to page 78, Lordship.
70.
78, Lordship.
78.
8.
Huh.
It's a type copy of the statement recorded by the petitioner before the Lordship inquiry committee, Lordship.
No, this is the preliminary inquiry.
Preliminary inquiry. Preliminary inquiry.
Okay, fine. I got it. I've taken note of that.
It's a admitted fact, Lordship, page 79. She herself admitted that,
Okay,
Lordship.
I got it.
She herself admitted.
I got it.
When there is an admission, Lordship, no need for, Lordship, regular inquiry, as part of case code, Lordship.
Show me that.
As part of-
And before that, why don't you place the show cause also?
Lordship,
Before you go to the inquiry report,
Lordship,
Supreme Court decisions, why don't you place the show cause?
Lordship.
Show cause and the penalty.
So, course is there on the basis of the inquiry, Lordship, that part of inquiry, as because there is an admission, Lordship, and CS also filed reply, Lordship,
Okay. Okay, Mr. Gogoi, one question.
Lordship.
Your case is that there being an admission in the preliminary inquiry.
Preliminary inquiry,
So
Lordship.
that is enough.
Lordship.
Then why did you go and issue a show cause notice?
Lordship, on the
You could have terminated her on that only.
Lordship, on the basis of inquiry, preliminary inquiry, authority has issued a show cause notice, and the CS replied, Lordship, authority is not satisfied as there is an admission, so authority issued the order, Lordship.
Admission where?
Admission is there, Lordship, 79 itself says that, Lordship.
Okay.
79 itself says that.
So you mean to say
Lordship,
that the order of penalty, which we find at page 103,
Lordship,
is the result of the admission of the petitioner
Lordship, Lordship.
before the preliminary inquiry. Okay.
What is it, one also? Today, before Lordship came, I have got the file lordship. Even I have not gone through it also lordship.
Okay, then. Are you sure with this statement of yours? I've recorded it.
Lordship.
If that is the stand,
It is there, lordship, page 103, lordship.
Hmm.
Having considered the reply to the so-called submitted by her and the report of the inquiry officer, so and so, then deputy secretary, so and so, there is the report, lordship, the inquiry officer report enclose all the statement of the
fine,
income, lordship.
fine.
All
Got
the
it.
statement.
Hmm.
So on the basis of the report, the authority have taken the decision, lordship.
Okay, fine.
If that is there, lordship, then there is no need for a further inquiry, lordship. Yeah, I am relying, lordship, 2009-11 SCC.
Just a moment, just a moment.
Okay, sorry. So continue now.
Yes,
Yes, sir.
you're relying on?
Lordship 2009-11 SCC 222. 2009-11 SCC 222, Lordship.
Name of the party?
Name of, I will hand over the.
No,
copy,
give me
Lordship.
the name of the party.
So Himachal Pradesh Route Transport Corporation and others, another versus Hukum San, Lordship.
Total sum. Hmm.
It's
Okay, give me a
paragraph 12 and 13, Lordship.
Give me a copy.
Paragraph 12 and 13. And another one is, Lordship, Honorable Punjab and Haryana High Court, Lordship. I have just handed over the copy, paragraph 10, Lordship. It's a Kuldeep Singh and others versus Shiromani Gurudwara Prabandhak Committee, Lordship. It's decided on 17/1/2023, Lordship. Paragraph 10, I am relying, Lordship. Yes. And another one is, Lordship, our High Court, Lordship. It's a 2013 TGLR 784. It was passed by my Lord Justice B.K. Sharma, Lordship. And I'm relying paragraph 27, Lordship. 2013 2GLT 17.
In the second judgment, that Gurudwara Prabandhak Committee,
Paragraph
10.
10, paragraph 10, Lordship. Paragraph 10, Lordship. Paragraph 10. And Lordship, our High Court judgment, Lordship, it's a 2013 to GLT P59, paragraph 22, 23, and 27. Right. And another judgment of Honorable Supreme Court, Lordship, AR 1968 SC 266.
This is paragraph 22, 23, 27.
27. Basically 27, Lordship, 22, 23, and AR 1968 SC 266.
First, my lord is following the Supreme Court judgment.
Lordship, it is by following the Supreme Court judgment, and paragraph 27, Lordship, first 3 lines sufficient, Lordship. AR 1968 SC 266 Central Bank of India versus Kanumoy Banerjee.
Hmm.
I am relying paragraph 18, Lordship.
Was 1972 referred to here?
Lordship,
In our High Court judgment, 1972 Supreme Court was referred to.
Lordship, that was it is 1960. Paragraph. Yes, sir, Neha.
Okay. Okay, got it.
Paragraph 18 and 19 also, last judgment, Lordship.
Which one?
Lordship, it's 1968, AIR 1968 SC 266.
AIR 1968
SC 266.
266. Okay.
Paragraph 18 and 19, Lordship.
Mr. Gogoi,
Lordship.
paragraph 18 and
18 and 19, Lordship. 18 middle part I have marked, Lordship, and 19 also regarding national justice part is there, Lordship.
do one thing.
Lordship.
There is no affidavit on your part.
Lordship.
So just 2 pages.
So, Lordship, I pray for Lordship reconstruct the file, Lordship.
You did you go ahead?
Lordship.
What did they? You paribo second file too. Photo, he'll give you a photocopy.
Lordship, 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 Lordship.
You have 2 copies with you, writ petition.
One is junior's copy, but that,
You give that junior's copy.
that is my notes, your lordship.
Oh,
So,
He'll give you a copy.
will from court, Lordship, will from court.
They
So-
do not deserve that lapse.
Mr.
They do
Bachchan.
not deserve that lapse.
Huh?
It's a lapse, very serious lapse on their part,
What?
not filing affidavit, not producing.
Lordship said
I'm taking care of
2000.
that.
Not producing.
Sajay, I'm taking care of that. You just be there. Day after tomorrow morning, 10:30, whatever decisions you have cited and your submission that the admission of the petitioner before the preliminary inquiry committee that she was not in the state, she was in Lonavala doing
Lordship,
work.
Lordship, Lordship,
On that basis, the government had decided and issued 103.
Lordship.
Just that 2 statements and the decisions, just file it before me.
I have to file.
A written argument.
Written, okay, Lordship, will
That
do.
much should be.
Will do.
That
Yep.
much should be.
Will do. We have no option.
Put a copy to us.
Huh?
A copy to us.
Lordship? Sir?
Put a copy to us.
Yeah. With a copy too. My senior.
Lord,
But
on 29.
I'll not allow you to change your stand.
No. I will not change. I will not change my stand even it was recorded, Lordship. Lordship may record it also, Lordship.
It's
in the-
already recorded.
Lordship.
It's already recorded.
Lordship, already recorded. I will not my stand, Lordship. And it is my not practice also, Lordship.
That,
Lordship.
Lord,
but Mr. Gogoi,
Lordship, I will
it's not this stand. I
Lordship,
got your points.
I will clarify, Lordship.
You just give me
Lordship.
that in writing. That's
Lordship.
enough.
Lordship.
2 words, 2 paragraphs. That will
Lordship.
do for me.
Lordship,
And I'll take it to be the stand of the government.
Lordship, I will pay on 29, Lordship. It last 2-3 days I have difficult.
If you want it on 29th,
Lordship.
then that will have to come from your secretary.
Lordship.
That statement will come from your secretary. That this is the way, this is why we have imposed.
25
Yes,
no? Executive.
if they
wait,
bring
no.
on record a statement, Mr. Gogoi is contending
Huh?
that there is an admission on your part,
Lordship,
And
on
that-
25th, Lordship.
25th.
On 25th. I will.
That admission is before the preliminary inquiry officer. Government took that admission and punished you. I said, bring that on record. That will do.
since your lordship is giving him time.
I'm not giving him time.
What that-
I'm closing the matter today.
No, your lordship will see. Another aspect, I did not place it. 311 have been amended. Thereafter, no second so was done. But constitutional bench say in a case that the giving a report of the inquiry report, giving inquiry report is part of the reasonable opposition.
Yes, Karnakaran and all those series of judgments. Mr.
So-
Bachchaji, you did not take the trouble of even venturing into that because it's a case of no inquiry.
I wanted to be Millard 100% sure.
I mean, you rest assured, I'll not go into that. You can give me that judgment if you want. Just give me the citation, that will do.
I'm giving a copy.
That will be great.
Your lordship may record Paragraph.
Karnagaran.
Here, my lord, it's a very interesting case, my lord. Even the petitioner does not ask for it, or rule does not provide it, still you have to give, because it's a part of the reasonable, the second stage.
And while giving it, the authorities should not apply their mind.
Yes,
It's only after receipt of that representation
they
they will
decide.
apply it. That's the beauty of this judgment. I got it, sir. You did not take the trouble, Mr.
Okay, this
sorry.
judgment has gone further, my lord. Today, even in private sector, it has to be.
Huh. Any proceeding done, forget 311. Even this private schools, non-governmental education act, that also provides
Yes.
that you will have to give a. That's a facet of natural justice now.
No, once your lordship is in a position to hold, there is no inquiry. It's not.
Mr. Vachaji, I have no problem on the first day itself to hold that there is no inquiry. My concern is with regard to the second part, the relief that will come to you. I'm more concerned with that. That's why I'm hearing you. Mr. Doctor, I'm allowing them to file a small written argument with their contentions. You need not be elaborate, just whatever Mr. Vachaji has argued and the judgments. You can give me a 2-3 page note on Thursday. We will proceed.
When your lordship is fixing it.
I'm fixing it on 25th. 25th. So I get 26, 27, 28 to work on it.
It's beautiful judgment. To work out a beautiful judgment.
I don't know. My language is not that very rusty. It's rustic. I am a pointsman. Sir used to always scold me for that. That I'm going to go into details. I try to cut short my arguments when I was that, sir. And that's the thing I used to get from sir always.
On the very
You
first
remember
day,
that?
Lordship, on the very first day of 2005, Lordship, when I was enrolled in the bar and in the High Court, Lordship, I always follow
I think, my
sir.
lord,
It's a fortune for me that sir is appearing.
I always follow sir.
to be on the safe side, a particular gazette notification should be consulted. Diwan's book is not first.
Mr. Bachaji, Mr. Gogoi, try to get that 98 notification.
Lordship, I'll try.
Because Mr. Bachaji, that book, if you see, I'll do my homework, don't worry, because I still have this thing that this thing was brought back either in the fifth pay commission recommendations or in the sixth pay commission. I forgot. I'll do that. It'll be with me somewhere. I'll find it out.
Then Lordship,
But
that-
if his point on that is accepted, yes, Mr. Bachaji, if his point that 50, 55 is accepted, then your voluntary application as on 2007 may not be proper. Then we will have to go only with the inquiry. Give me a small note. And also therein your date of birth.
Yes, it is.
Your date of birth is?
I've just got it. 12th of September 1959.
So she will be 50 years in 2009. 50 years in 2000. So if that be the position, we will not go into, we'll note it, we'll note your submissions, but we will not allow your voluntary retirement application. Because if it's not within the scheme, if 23 years have been removed,
My lord,
these books are very deceptive. You can't.
my lord, I will not be prejudiced first because he is reinstated.
You will get
Bound
more.
to get the
You'll get more.
Lordship, whether we have to clarify that volunteer part also. Only
Yeah, if you can get that 98 notification from him.
Lordship.
You can get that 98 notification.
हमको दिया सुना reference, notification reference.
You get it in that. Give that book to Mr. No, 98 or reference. 98 or reference पे book code किताब होता है. Mr. Doctor,
Yes.
that book Mr. Gogoi had produced,
Which one?
if you go to K1, 56K1, below you will get that 98 gazette notification.
Period for which it was not in operation.
Not in operation, no. They deleted C
Deleted.
and then incorporated that provision in K1. 56K1. And therein it is 50 for a particular circumstance and 55 for others. So that period of service was taken away.
Service.
Was taken away. Because maybe it was like this, a person who was in service, say joined maybe 40 years, 45, 40 years also you can join. You become 50, 10 years service, you are submitting an application for voluntary retirement.
That's logic, Lossi, it's
That
55.
may be the logic why
55 was.
this was done.
55.
Brought in.
But I don't know, I'll have to consult it. So, Mr. Bachchaji need not come. You just submit that. We'll have no more hearing. Okay?
As per your lordship, the remembrance 56 he was brought in later.
Huh?
Lordship was saying it was brought in later on, the earlier.
No, 98 notification, as far as I could gather, that gazette notification, 98 amendment, they removed 56C
But it was
and
later on
incorporated it as K1,
A1. Yes.
removing the period of service, placing it only the age. You have a look. Mr. Vachaji, I'm closing the matter. I'm only keeping it on Thursday as a parted matter. Hearings concluded. Only the arguments I'll receive and then I'll fix it. I'll save it and fix it for judgment.
Yes.
Thank you.
Today,
And
today we can assess the.
you can take a Xerox of that, no problem.
We'll make it Xerox.
He'll give it to you, make a Xerox,
Ah.
come back, give it to him. That much we'll do for you.
Apologies.
Mr. Vatsaji, let me see how far I can go. But the way I had formulated my thoughts today was on the plea that you had retired and thereafter I had got all the judgments. Anyway, fine. Don't trouble Mr. Bachchaji on that day because there'll be no arguments. You just give it.
Your lordship knows the service matter clients. They will not allow you to sleep.
That's true. And that's one relief I have after coming this side. Oh, ekini khumai dibo. 25th. No. Patat. Heard Mr. A.K. Bachchaji for the senior advocate for the petitioner, assisted by Mr. S. Doctor. Also heard Mr. A. Gugoi, the standing counsel, Higher Education Department. Hearing. I have heard at length. Oh, stop. List this matter again on 25 to 2024 at the top of the list. On the next date fixed, the parties are permitted to submit their respective arguments, respective written arguments in the line the matter was argued
Today.
today.
Apologies.
Item 2 and 3.
Yes, Mr. Chaudhary.
Lordship, directed for the production of the record.
First, I would like to hear you as to why you have done it. Whether 54 notification was applied at the time of their deployment.
Lordship, from the documents in the writ petition and in the affidavit, I will be submitting from the basis of those documents because the records I have not received, Lordship, where they are trying to locate it since it's an old record.
Okay, fine.
Lordship has seen that the post in which the petitioners were appointed initially, those were temporary posts and they were retained for a specific period. Thereafter, Lordship, in Annexure 10, page 38, Lordship, that amalgamated
No.
gradation.
Before that, you come to Annexure 9.
Yes,
Those posts were permanently retained.
those posts were permanently, those temporary posts were permanently
Retained.
retained. The Lordship, only the post. It doesn't say, states about the income.
Post retained, they are already holding the post according to your.
Yes, Lordship.
So they need not be retained permanently.
Yes, Lordship.
They are permanent employees.
No,
They have been
Lordship,
confirmed.
confirmation is subsequent, Lordship.
Fine. But they have been now, initially their appointments were for a particular period of time,
Yes, Lordship.
right?
Page 26, Lordship, initially for 3 months.
But it is in pursuance to a due process of solution
Yes, Lordship.
against a vacant sanction post. And then the authorities were writing, but the government did not. Now, if you come to Annexure 9,
It's a renewal of the retention sanction, Lordship.
are retained permanently with effect from 29/2/2004.
Yes,
Okay. So now if you come to that page 38,
yes, my lord, that amalgamated gradation list of the ministerial cadre, and wherein, Lordship, both the petitioner's name were at 514 and 515 serial number.
okay, now you just come to that
And
page
Lordship,
40.
in the same page 40, Lordship will find the in the
Not confirmed.
not confirmed.
Fine.
Lordship.
Now you come to Jointo Sharma at 631. Next page.
Yes, madam.
He is also not confirmed.
Not confirmed, Lordship.
Then now you come to page
Not
42.
confirmed, and Lordship, he was in the meantime, during that period, he was promoted,
No,
junior assistant.
no. This
The
is
column
after
state.
promotion. Page 41, his name is incorporated after promotion, not as a grade 4. If you see the second column,
But Lordship, the list states that it's a gradation list as on 1/11/2007.
he was promoted on 2/9/2006.
2006, that's right, Lordship, after his promotion.
After his promotion as junior assistant, this list came.
Yes, ma'am.
Then now you come to page 42. 42. This is an order of the government.
Yes, madam.
The first one you forget, first paragraph, abolish.
Second one is,
Consequent upon abolition of the check post, the officers and staff working in there will be relocated at Nagaon, Tezpur, and other places where there is shortage. Now, tell me one thing. This is of 14/7/2008. This is the only clarification I require. And your amalgamated gradation list is of 25/2/2008. Right?
Lordship, this is the forwarding, but the 2007 is the point of determination.
Fine. 1/11/2007. You have finalized it. This was a gradation provisional one given. If you read page 38, you will find provisional gradation list issued, thereafter confirmed. Right?
Finalized.
Finalized. So that means all these people are in one cadre.
Yes, ma'am.
So then how do I understand 14/7/2008 without there being a explicit provision there? or a disclosure there that they will lose their seniority. Because 54 office memorandum was never contemplated here. It was only contemplated in the speaking order.
But Lordship, till that point of time of issuance of this gradation list, the petitioners were not confirmed. Because they were-
Jayanta Sharma was also not confirmed.
Yes, yes, my lord. Subsequently, the decision was taken to abolish the check post.
Yeah.
And they were relocated in the,
See,
Various-
that's my question. They may not be confirmed, but they are regular government servants.
Lordship, they are in the nature
Confirmation,
of
as
temporary
there is in a
employment.
judgment, it's anybody's guess when you will be confirmed. So,
Confirmation which will be with regard to a person who is appointed in a permanent post. They were appointed in a temporary post
no,
and the post were subsequently retained, Lordship.
retain, and the retention is enough.
Retention is the post, but
Have you, after this 2004, 4 years, they were working there.
Yes. Because the post were, since continuously for more than 5 years, they were working at the time of retention, the post were retained.
Hmm.
It's specific, Lordship, that since the post were continuing for more than 5 years.
That post was requisite
Required and it was retained.
continuing for 5 years. That's why you said that post continuation is required.
Yes,
So you continued it.
yes,
So
Lord.
those incumbents, otherwise, Mr. Chaudhary, their name would not have been included here.
Since they were, because
If they are employees under the commissionerate, they are employees under the commissionerate. So if they are employees under the commissionerate, they are equally placed as each member whose name has been incorporated.
that's where lies the issue, Lordship, because their nature of appointment was temporary. Even though they were working in the permanent return post, their names were included for the purpose only of the issuance of the seniority as it appears, Lordship. Subject to correction from the record, Lordship.
The
And-
record now after 2013, we will not allow this thing to go on.
Yes, sir, true, Lordship, they have not.
Okay, now next submission. And tell me about 54. OM of 54.
Lordship, may kindly turn over to page 46.
Hmm.
And except 14, Lordship, the representation was given by the petition on 3/10/2008
Forget the representation.
for fixation of the interstate seniority.
We are not
Lordship,
concerned. We are
Lordship,
not concerned with
that's why, because till that day, her nature of appointment was temporary. And Lordship, the annexer 21, page 54, Lordship, right at the beginning, the joint secretary stated that he is considering that representation of 3/10/2008. Though subsequently in 2010, she was confirmed with effect from 1/10.
So you mean to say this is wrong? The
Lordship,
subsequent fact was not
in
taken into-
respect of that, at that point of time of submission of that representation, it determined the issue. Because she was relocated in the new
This is the
office.
beauty of Mr. Chaudhary. He can
No.
hold up
Lordship,
things.
I cannot, Lordship.
Mr. Chaudhary, I understand where you are leading me to. That argument, let us test. We can only test with the stand of your authorities.
Yes, ma'am.
Come to page 49. Come to the third line,
Lordship, page 40.
49.
No service rule, Lordship.
No. Third line, 49. That is a letter from Sanjay Lohia, Commissioner of
Yes,
Tax.
Lordship.
So he is the authority for all of them. He's the top. Divisions are under him.
Yes.
Then comes the government. Read that with reference to the government.
With reference to government letter cited above, I have the honor to state that as Srimati Deepa Borgotogi, Junior Assistant, and Sri Dijan Soikia, Junior Assistant, had rendered their service as Junior Assistant in the erstwhile Office of the Superintendent of Taxes, Batamari Check Post since 3/12/1994, and
read this very carefully.
and as they were transferred and posted in the Office of the Deputy Commissioner of Taxes, Tezpur, and Assistant Commissioner of Taxes, Tezpur Unit, Tezpur respectively, in the interest of public service, in pursuance of government letter dated 14/7/2008, a prayer for determination of interstate seniority at their place of posting, according to our view. It's a suggestion, Lordship, according to
No,
our
he is
view.
the authority. He is the controlling
Deserves the-
authority. He is the
Deserves
controlling
due
authority.
consideration.
Their interstate seniority.
Their interstate seniority may be fixed from the date of joining in erstwhile Patamari check post for the purpose of promotion in future. Further, the information as desired by government
There
of
is
furnished
that,
below.
that you can forget. Now, this last line of the first paragraph, you will have to read it with that middle portion, and they were transferred and posted. So if they are transferred and posted, that means they are equivalently placed with all those persons whose name figure in that gradation list. Okay.
Lordship, but
Next.
Lordship, the commissioner suggestion said that they were transferred in the interest of public service in pursuance of government letter dated 14/7/2008. And Lordship may kindly take up
Page,
page 42.
42, huh?
Yes, Lordship,
Here it says nothing.
nothing. But
Nothing.
he
Neither
cannot,
this way
he
or not the
cannot,
other way.
Lordship, but though
So
he
we
may
will
have used
understand,
the word
Mr.
public
Chaudhary,
service.
Mr. Chaudhary, what I want from you is, this orders, page 42 says nothing,
Yes,
right? Then we have page 49, the earliest one, proximate to that. And this is the view taken by the authority. Is your authority?
Lordship, his only view, Lordship, because the government will be fixing the
No,
interstate.
he has stated a fact.
Yes, Lordship, on the basis of the fact, he has forwarded his view. And it's for the government to decide, take that.
Okay, okay.
View
Now you
into-
come to the government at page
Yes.
54.
Relevant part, Lordship, starts from the third line from the bottom, last paragraph. With the evolution of the check post, the existing post created or retained for the check post to abolish. The grade 3 and grade 4 staff working in the check post ought to have been retrenched, but
Okay. Now, where does he get this words ought to have been retrenched? There has to be some finding somewhere.
yes,
It's
Lordship,
not
that's
brought
what-
on record.
That's what,
And till before 2011, this finding was nowhere there. Even the letter of the commissioner would have said that. Now you read further.
but they were relocated and posted at other offices under finance taxation department.
On
purely
humanitarian grounds.
on humanitarian grounds.
So the order of the government that was issued was a order issued on humanitarian grounds.
Yes, Lordship.
Then why page 49, the commissioner is saying something different?
Lordship, that there may be
Go ahead,
something in
go
the record, Lordship. I can't go beyond.
You
the-
can come. The unit zone recovery and check post officers are independent officers separate from each other.
Yes,
And the officers in charge of this are appointing authorities in so and so. There is no service rule governing the service condition of ministerial staff working in the officer. As the applicants are posted in their present offices on abolition, so and so, their seniority will come down below the existing last man, 54. So now you bring in 54. Where is that application of 54 before this? You can't apply retrospectively to that order which was issued in 2008, in 2011, 54. OM 54. Can you?
Lordship, it will be on the, though the order has been issued in 2011, but the seniority will be count with regard to the last man of the 2008 lawsuit.
No, how, why I'm saying, that's what I'm trying to tell you. In 2008, that prescription is not there.
Yes, 54, nowhere it is mentioned.
In 49, page 49 also, it is not there. If it is 54, it cannot be transfer and posting. Can it be?
No,
So, till 2009, you have not utilized 54. Now, that means when the order was originally passed, 54 was never contemplated. Contemplation came when you disposed of the writ petition, whether that is permissible.
but a lot
And that too without giving them a notice.
a notice, but there lots of, if the authority wants to imply.
Because here, what you are
54
saying,
OM.
it's taking out everything, it's wiping out a part of their service.
Part of their service, but lordship, the government order was considered on the basis of 2008 representation, and she was transferred somewhere 2 months back in 2008. And though the wording are transferred and relocation, but since their appointment were in the temporary nature, naturally they ought to have been retrenched, but
Okay, I accept your argument. You come to page 44. This is by the commissioner.
yes, ma'am.
This is a posting order. Is it an appointment, permanent appointment? If their appointments initially are temporary, they'll continue to be temporary wherever they are. So, how come the commissioner issued a posting order and not a redeployment order? Abolition, retrenchment, redeployment, right? Three concepts.
Lordship, they, at that point of the, I don't think
It's better not to go further.
Yes,
Yes, who is appearing for the, this is what you have finally to say. Who is appearing for the private respondent? Yes, what do you have to say?
Look, so far as the application of 54, that is the law, Milord. And Milord,
Law.
yes, that is the law, Milord. And Milord, that when 42, at page 42, the order was passed, where no reference of the circular of 52, 54 was made, it is not required, Milord, because it was passed in accordance with law, Milord.
Which one?
That 42, the
Page
order
42.
at page 42 was passed in accordance with law. And that is why no reference is required to be made in the order, Milord.
Next.
If they want to exclude, only in that case, that reference is to be made. And 54 circular is clear that in case of retrenchment or in case of abolition, the incumbent will not get the benefits of previous service, Milord.
Okay. Just to test your argument, page 61 is the circular. When?
Page 60.
61. Or you can come to page of the affidavit. Yeah, that is it, 6. That is the one. Or you can come to the affidavit filed by Mr. Chaudhary at page 32, 30.
Page 30.
13 then. Internal page 30.
Yes, my lord.
You come down below. Concessions to state government servants retrenched and reappointed in another state government office. Word is reappointed. Where the petitioners reappointed or where they transferred and posted.
He in the 42, page 42, word reallocated is, my lord, used. The word reallocated is used.
Okay, where they reappointed, was there a fresh order of appointment? If they are retrenched, there has to be a first order of appointment.
But that itself is
You
a
come to
abolition.
page 14. No. We'll go by 54 strictly. Come to page 14. That page, that document. Come to 2.
Yes, my lord.
Read that opening line.
Page
If the orders of appointment to the new post are received by the government servant concerned soon after retrenchment from his post. So, let's hope they are retrenched employees. Let's take it for argument. Where is that reappointment?
That 42 itself, my lord,
That is not reappointment. That cannot be a reappointment. Reappointment would be a fresh appointment ignoring their other service. This was done in continuation of the service. Now you are still serving.
my lord, yes.
You are still a UDA,
Yes.
senior assistant.
Yes.
What is that?
This is regarding abolition and paragraph 5 and 6, my lord.
Okay, this again goes against you.
My lord,
Para 6.
paragraph 6.
It is now settled so and so that the holder of post has no right to continue.
Yes,
Instead of retrenching him as a surplus, the government have accommodated him in an available vacancy. Therefore, it must be deemed to be fresh appointment for the purpose of seniority.
deemed.
Okay,
Deemed.
read further. After joining in Salem in so-and-so, he made a request for transfer to so-and-so. And it is his request that he was transferred. Consequently, on his undertaking the application that he would not claim his seniority at the Salem station, the transfer was effected at his request. It is settled legal position that he would take his seniority as junior most among the confirmed employees in the transferred region.
Yes,
Now show me that you are confirmed.
yes.
On that day.
Yes, same day.
No. On the date she joined your establishment.
No, because
On the date,
her confirmation.
that is
And my
subsequent. How can I?
confirmation is the same.
No. The Supreme Court judgment says, you go there, whoever are confirmed, there you will be bottom of that.
Yes,
So we'll apply it in your case. On the date she joined your establishment, where you confirmed.
but my lord,
Forget the subsequent action. On that day. Seniority will be determined on that day, not in 2010. Last line.
but her appointment is deemed to be on 2008, my lord. Suppose confirmation is the same date, my lord. Appointment was prior. My appointment was prior to her, my lord.
Prior to you. How?
Prior to her.
How? When were you
When
promoted?
confirmation.
You were promoted in 2006.
Yes,
And she is working from her initial date of appointment as LDA.
but she will not get the benefit, and this judgment itself
Okay.
says that deemed to be appointment, my lord. If confirmation is the same, then her appointment is on 2008 by applying this law. And I was promoted on 2006, my lord. From that angle, I am senior to her.
Okay, fine, accepted. Yes, Mr. Das.
Fine.
Any reply?
It would have matched that on the last occasion, I was supposed to Before Lordship, with the decision of this honorable court, my lord, while about the.
My Lord Justice Koteshwar Singh's order.
Yes.
I know that. I was there. I know that.
After that.
It's here, 6149/2018.
Yes, correct.
Alimuddin, and there is one more. Good order, Sandradikar, yeah.
That,
But I'm going a step further.
well,
I'm going to the root. And on 3rd December 2019,
Oh.
the government had taken some decision that they will fix the seniority in terms of the High Court order.
Okay.
Right?
Right.
So that order is also there. Fix the seniority of grade 3 and of abolished check posts under finance department who were later adjusted in different under the administrative control so-and-so as per the order of the Honorable High Court in so-and-so in the present post.
Yeah.
Then it will be.
Decision of your commission secretary to the government of Assam. Finished. That's the end of the matter. I didn't see this.
Hello. Definitely.
Now, Mr. Das, he is working from 2012.
Well.
You have been promoted in the meantime.
Yes, my lord.
Both of them have been promoted.
I was promoted in the prior,
Where these two persons promoted?
that I cannot exactly say, but I have.
Have you been promoted, Mr. Das?
No, not yet, my lord.
Sure.
No, not yet. That they actually interesting, my lord, about the reason they will be retiring, my lord. If petition, the Depa board he will be retiring on 28/2/2024, my lord.
24.
24. And the
28
other
to
also,
24.
other also the same, and he will be retiring on 28/2/2024, my lord.
Promote them with effect from the date he was given promotion with seniority, but no back wages, no arrears, only prospective promotional benefits. So they retire with a package. That's all.
Lordship may, in the meantime, the seniority part also, Lordship may do some direction. That part.
I'll follow the thing. You are retiring on 28/2.
Yes, my lord. One is 28/2/2024, and the other one is 28/2/2024, my lord.
Petition number 1.
Petitional, she will be
Depa board
retiring on
photo
28/2. And that's the same date, my lord. Sorry,
28/2.
24, 2024.
And both of them are in the same office. ACT and DCT is same.
Same office, my lord.
No, Lordship.
It's different offices.
Different. Now,
So in case of Dijan Sharma, we will only say that
Fine.
because he has not been superseded. In his office, he has not been superseded. So we will say he will be entitled to his seniority from that day,
my lord.
and whatever consequences follow will follow.
Well.
You are appearing in both the cases for the private
Yes.
response.
Similar, but by the time in view of this or the judgment, also in my lord, there's WPC number 6149, they could have got the seniority list, my lord, by complying with their direction.
Respondent number 5 has filed an affidavit.
Well.
You have filed an affidavit.
Yes,
here. Mr. Shah will not disturb you. Will not disturb your services,
Yes.
will not disturb your promotion,
Yes.
but we will ask them to be granted the consequential benefits. Anyway, they are retiring. Jackie,
But each time the petition put the their services have been confirmed, my lord.
I know. This was again. Bill pass on.
Public.
Item 4 and 5.
I plead your lordship. Lordship, I beg to argue in this matter as on behalf of my senior Mr. S.K. Mehdi, as he is out of station.
Welcome. Go ahead.
Lordship, the petitioner was appointed in the post of LDA in the office of Principal, Assam Engineering Institute, fight order dated 6/9/1961. Thereafter, the petitioner was released from Assam Engineering Institute to join as UDA in the office of Panchayat Raj Training Center, fight order dated 31st March 1967. And accordingly, the petitioner was appointed as UDA in the office of Panchayat Raj Training Center, fight order dated 4th March 1967. Thereafter, the service condition of Panchayat Raj Training Center employees same as government servants, but FR, SR, and other government facilities are not provided to the petitioners. Therefore, the petitioner, along with 9 other similarly situated persons, approached this honorable court by filing civil rule number 4140 of 1996 before this honorable court. Now, Lordship may have a look at the order passed by this honorable court.
Page 25.
Page 23 is type copy, Lordship.
Can come to page 25.
Page 29. May I read your Lordship? The Commissioner and Secretary to the Government of Assam, Panchayat and Rural Development Department shall consider the case of the petitioners and pass appropriate orders in order to declare the petitioners as government employed so as to make them eligible to payment of pension, gratuity, and other retirement benefits on the retirement of superannuation, and also for making eligible for such payment to those persons who have already retired on attaining their superannuation. But Lordship, in compliance of this honorable court's order, they neither pass any appropriate
No,
order.
come to para 10.
Para 10. However, in the interest of justice and for the sake of equity, I allow the Commissioner and Secretary to the Government of Assam, Panchayat and Rural Development Department 6-month time from the date of receipt of this order to frame a scheme in this record in order to afford socio-economic security to the petitioners.
Okay.
Considering the entire factual aspect as stated in the writ petition, it is made clear that in framing such scheme, the said authorities shall be at liberty to take all the necessary assistance and cooperation from all the interested authorities concerned.
Okay.
But thereafter, Lordship, in compliance of this honorable court's order, they neither pass any appropriate order nor challenge the honorable court, this honorable court's order. It came to the knowledge of the petitioner in the year 2011 when the Finance Department filed affidavit in opposition in an contempt petition filed by some similarly situated persons, that only the case of one person is considered by them.
Siddheshwar Bova.
Yes, that is respondent number 5, Lordship. Now, Lordship may have a look at Annexure 8, page number 47.
50?
47.
No,
Lordship.
47. That endorsement of the finance.
Yes, Lordship. May I read your Lordship? Since Sri Siddheshwar Barua was in government service before joining the service of PRTC, and thus his service at PRTC may be treated as on deputation.
Okay, fine, got it. You can
They
skip that.
didn't say that he was on deputation. They said that he may be treated on deputation.
Okay. What is your submission now?
I pray for the pensionary benefit that is given to Mr. Siddheshwar Barua.
But you're not a government employee. You are not a government. You were not in government service. Other than the petition number 1, who was shown to have been appointed as an LDA in some government office. But
I was also
there
appointed
is
as
nothing on record to show that that appointment at page 17 is a regular appointment.
page 17, Lordship.
Petition, Rajendra Kumar, Chandra Kumar.
Yes, Lord.
This is in the Assam Engineering Institute.
Yes, Lord.
But there is nothing here to show that this is a regular appointment. And you have also not said in your petition that these people, these petitioners are regular. In absence of a scheme at this late juncture, what can we do? Is the institution presently covered by pension scheme?
No, Lord.
No. It's still under a society.
But in the civil rule, we pray for regularization of service, and Siddheswar Barua was also one of the petitioners.
I got it. Siddheshwar Barua has a service in the government.
Yes.
And accordingly, he was sent on deputation. But you cannot show that your service and Siddheshwar Barua's service is the same. No statement to that effect anyway. And the second case is also the same.
Same.
Yes. Mr. Kumar, what do you have to say?
Your Lordship, so far as the Siddheswar Barua is concerned, at the time of he was working in another department, at the time of
The petitioner is also working in another department.
Yes.
Why he is not given
the
that?
difference is that your Lordship, the Siddheswar Barua has submitted an application. He will join in the new post if it is treated as on deputation. And government taken the decision that
No,
he is on.
no, sorry. That joining occasion sometime in 61, 62, 63, 64. You come to that.
Otherwise, also your Lordship, the petitioners join the organization which is not a government establishment. Your Lordship. Yes, they
He
were
joined
working.
in 62.
Yes, sir.
Siddheswar Barua.
Yes.
So 62 he came. So from 62 till 2008, how was he a regular employee in the other organization?
Your Lordship, they kindly see the page 6 of the affidavit, Your Lordship. Page 6 of the affidavit. Annexure. Page 6.
Affidavit.
Yes, Your Lordship.
Is there an affidavit received by you?
In item number 5, there is a.
5.
Yes, sir.
Okay.
Your Lordship, kindly see, this application was submitted by Siddheswar Barua. Okay? It was submitted on 5th of May, 1962, Your Lordship. The last paragraph, Your Lordship, kindly see, in the light of the above particulars, I earnestly hope that you will be kind enough to consider my case.
Okay, done. Got it. Then next. Now what to do with these people?
Your Lordship, that it is,
There was a direction from this court to frame a scheme.
Your Lordship, that subsequently, yes, Your Lordship, that
The contempt.
Your Lordship, the it was considered by the department, and accordingly it was forwarded to the finance department, and finance department has taken a stand that his petitioner's appointment in the subsequent organization is a fresh appointment, and if those organizations are not a government establishment.
Okay, got it. Yes, Mr. Consul.
Lordship may have a look.
And your lordship, that on the basis of that finance stand, your lordship, this second writ petition was disposed of because the second round of litigation was also here. And they even the liberty them to challenge the finance that. So the earlier or direction from this honorable court goes, your lordship, because department considered and liberty was given to us to take the assistance of the other concerned departments, your lordship.
Yes, Mr. Consul.
Lordship may have a look at Annexure 2, page number 19.
First writ petition.
Yes, Lordship. Release order, Lordship.
I got it. But what Mr. The additional AG is pointing out is that deputation concept came into being because he had specifically asked for that at page 6 of the second affidavit in the second case, Siddheshwar Burwa. And accordingly, he was given from 62 to 95. And he was transferred to the office of the Assistant Development Commissioner, Churar, because he was working in the same department itself. Anything more?
I leave it to you.
Your name?
KK Medi.
Heard Mr. KK Medi, Learned Counsel for the petitioner. Also heard Mr. P4 Learned. Additional, you are as an additional AG here or Mr. Or you are
as additional
AG? Comment of Assam representing the respondents number 1, 3, and 4. Who appears for the finance?
I'm representing also.
You are representing. Who appears for all the respondents? The petitioner has, by way of the present petition, raised a grievance with regard to non-consideration of their cases for being conferred with pension and pensionary benefits on account of the services rendered by them in the Panchayat Raj Training Center at, you all are at Joynagar, Kaikusi or Arunachal?
Kaikusi.
Kaikusi, at Kaikusi. Both of you. Both the writ petitioner.
I don't know, but my senior is engaged only in item 4.
At Kahikusi. So, the facts requisite for adjudication of the present proceedings is noticed here. So, the petitioner, who was initially appointed as a lower division assistant in the office of the principal of Assam Engineering Institute, Guwahati, on 6/9/61, was released from the said organization, permitting him to join as UDA accountant in the office of the Panchayat Raj Training Center. Also, the petitioner accordingly, on his such release, was appointed as UDA assistant by the chairman, PSS Assam State Guwahati, at the in the office of the principal Panchayat Raj Training Center. The said center was so established under a scheme of the central government with a view to provide training facilities to elected representatives of Panchayat in order to equip them to shoulder the responsibilities involved in their area of work. Also, the said society, that organization is managed by a society And the finances of the said institute is provided as a grants in aid. Grants in aid by the government? You provide grants in aid?
It is your lordship the under scheme, central government financing,
Again, no, like,
under scheme, your lordship.
and the expenses of the said institution is borne from these funds allotted to it under the scheme. The petitioner, upon joining the said had prayed, petitioner along with other staff of the said training institute had prayed for regularization of their services to the authorities. And the same not occasion, the petitioner approached the school by way of filing by way of instituting a petition being civil rule number 4140/1996. This honorable court, while order dated 19/6/2021, after noticing the facts involved and also the nature of the service of the petitioners, disposed of the said petition, requiring the government to prepare a scheme for provide pension, gratuity, and other retirement benefits to the petitioners. So the relevant portion of the order, relevant paragraphs of the said order is extracted herein below. Page 29, A to A. Also, it may be noted here that the petitioner were being given all service benefits other than the pension and pensionary benefits in accordance with that of government servants of equal status working in other government institutions. Also, the directions passed by this court, as noted herein above, as directions passed by this court quite order dated 19/6/2021, not being complied with, the petitioners had a person similarly situated like the petitioner had instituted a contempt case being 217 of 2007. It is to be noted here that after the passing of the order dated 19/6/2001, the matter was considered by the department, and a proposal was placed in this connection with the finance department. The finance department, wrote an endorsement dated 2/4/2008. Rejected the case of the petitioner and others. Holding that the petitioner, being an appointee of the institute, they are not entitled to a pension or pensionary benefit. Also, however, by the said note, one of the petitioners in civil rule number 4140/1996, that is Siddheshwar Borua, was accorded approval for being authorized pension and pensionary benefits by treating his service in the Panchayat Raj Training Center as on deputation. So, this aspect of the matter was brought to the notice of this court while considering the contempt application being COPC number 217/2007. and this court quite ordered it in 19/4/2012 on accepting the set develop was pleased to close the writ petition by permitting the petitioner's hearing to challenge the decision of the finance department as regards similarity or dissimilarity of the present petitioners with Sri Siddeshwar Barua by filing appropriate petition before this court. It is in this context that the present petition has been filed by the petitioners before this court. Also, although, it is to be noted that the scheme that was directed to be prepared by this court by order dated 19/6/2001 was never prepared, but the matter on being considered culminated in the decision rendered by the finance department by its endorsement dated 2/4/2008. Also, the petitioners, although had filed contempt petition alleging violation of the directives passed by this court, white order judgment and order dated 19/6/2001. The same was disposed of basing on the decision rendered in the matter by the finance department, rendered the matter by the finance department. Also, accordingly, the directions passed by this court, white order dated 19/6/2001, having not been held to have been violated by the respondent authorities, and the decision of the finance department having been accepted with liberty to the petitioners to challenge that to the extent as indicated herein above. The directions as contained in the judgment and order dated 19/6/2001 now cannot be directed to be complied with. Also, this brings me to the consideration of the contention raised by the petitioner in the petition, and as well as pressed today in the hearing by the learned counsel for the petitioner, that he ought to have been given similar benefit as was extended to Siddeshwar Barua, who was a co-petitioner along with the present petitioner in the proceedings in Civil Rule number 4140/1996. Also, Sri Siddeshwar Barua, who was working in a government service before joining the services of PRTC, was authorized pension and pensionary benefits by treating his service at PRTC to be one on deputation. Full stop. Mr. Kuan, Learner Additional Advocate General, in the hearing today has drawn my attention to the affidavit filed by the petitioner, by the respondents in WPC number 3717/2012, wherein in Annexure 1 thereof, a communication dated 5/5/62 of Sri Siddeshwar Barua is brought on record. A perusal of the said communication would show that Siddeshwar Barua was serving as an LDA typist in Demo Development Block since 1/1/1956-7, and thereafter he was transferred to the office of the Assistant Development Commissioner, Jorat, as LDA. Also, he had on his selection as Upper Division Assistant Cum Accountant in the Panchayat Raj Training Center, Barbheta, BARBHETA, Jorat, requested the authorities that he be appointed in the said institute as UDA cum accountant on deputation basis. Full stop. The said Siddeshwar Barua had accordingly, after submitting the said communication letter 5/5/2062, joined his services with the PRTC full query on 1/6/62. Full stop. It is in this context that following the directions of this court contained in the judgment and order dated 19/6/2001 in the CR number 4140 1996 that the Finance Department had agreed to authorize to the to Sri Siddheshwar Borua pension and pensionary benefits by treating his service in PRTC to be one on deputation. Full stop. The set traits as available in the case of Siddheshwar Borua is clearly absent in the case of the present petitioner, and as such, he cannot be permitted to claim benefits similar to that was issued, that was conferred upon Siddheshwar Borua. Stop. There is no material brought on record in the present proceedings to highlight the fact that the petitioner and Siddheshwar Borua were similarly situated in all respects, and as such the petitioner was required to be extended with the similar treatment. In absence of such materials on record, it is not open for this court to direct the respondent authorities to provide similar benefits to the petitioner as provided to said Sri Siddheshwar Borua in view of the said conclusions. And in view of the said conclusions, the contentions raised by the petitioner are not cannot be accepted, are without any merit, and accordingly the petition stands dismissed. However, there shall be no order as to pause. And next to a Eligible. The petitioner here, बाकी सब पैकेट है वो, हाँ, a कॉलअप चलिए आता है वो, ना अपनी ये तो मुझे वीडियो में पढ़ी, ये तो वो माइक है तुम कोई,
Item 6 and 7.
With please, Your Lordship.
Hmm.
Then, my lord, petitioner, Inferior Lordship's, my lord, is basically agreed by the inaction on the part of the respondent authority to fail the payment of the petitioner's, my lord, arrears salary as well as regular salary.
yes.
Well, in this case, I have not received any instruction, my lord. Here,
When will you? This is 12,
my lord, true, my lord.
12 years. How many more time do you want to receive? This is one order we pass here, it will be trouble for you.
My lord.
To contest this matters properly. Otherwise, I'm clear. I can proceed. You had regularized them in 2005. From that day, they are entitled to salary.
True, my lord.
Then we'll pass that order. You do?
My lord.
Yes, you.
After verify, my lord.
No verification now. You verified Director Elementary Education. Verified. Who is the Director Elementary Education at that point of time?
Here, my lord, as per the last communication, my lord.
You catch hold of him if he's done something wrong here. Yes.
My lord, here, my lord, last communication, last annexure, my lord, that is under, my lord, for SIU approval, my lord. That has been awaited.
See,
my
this SIU approval is of 2012.
2014, my lord.
12.
12, my
You
lord.
do one thing. We'll have it at 2. Just get the instruction. What is the present
My lord,
status?
today is holiday, my lord.
Are you holiday?
Yes, Netaji Subhasandu.
Next Thursday.
Thursday.
Fine.
Done. No, Thursday, no. Thursday will not be possible. 30th.
My lord.
Fine.
18th matter 6, 7, na?
Yes.
Item 6 and
6 and 7.
Obliged.
Thursday. Oh, Mr. Bora, that's the order.
My lord. On Thursday, if I'm not able to place any instruction on.
25th. No, no. 25th, no. 30th. 30th.
My lord. Obliged.
Obliged.
For further hearing, go ahead. Anything more you want to submit, Mr. Don't go back unsatisfied that you couldn't submit anything. No.
Item 8 and 9.
What brings you here? Huh?
I'm being led by Mr. M.K. Chaudhary. He's on
Forget
deck.
him. You are there, you argue.
My lord, I cannot argue this because it's an engaged matter. I'll be arguing item number 10, however. He is on legs in court number 2, my lord.
We'll have it after some time.
So it may be passed over for time.
Second up. Because this matters I am being giving time, the main list is still pending. So I'll have to go to that. Yeah. 10.
Item
Okay.
10. My lord, item 10.
Pranab Adhyapak.
Item 10.
Okay. Yes.
My lord, the prayer is at page 14.
Hmm.
I've laid a challenge to the
Right,
to the order dated 18/10/2012.
Page?
14, my lord. The prayer is at page 14. I've laid a challenge to the order dated 18/10/2012, which has been passed by the managing director of Fishfed at page 42, annexure 42.
Means you were imposed with a penalty of dismissal.
I was imposed with a penalty which my lord will find at page 36. Basically,
No, the initial penalty was?
my lord, the respondents had asked for a termination. They terminated me. The order,
Then this honorable court interfered,
this honorable court
said it's bad, but remanded back the matter.
remanded back, and if I'm reinstated in service, then I may be with any one of the lesser penalties.
You come to page 36, read
Yes, my
that
lord.
last portion.
The last one, my lord.
Hmm.
May I read it, my lord?
Hmm.
For all the aforesaid reasons, while not interfering with the impugned order of penalty dated 27/3/2001, the matter is remanded back to the disciplinary authority to consider as to whether the charge of unauthorized absence from duty, if considered independent of the other 4 charges, could entail the penalty of removal from service. No opinion is expressed in this regard, and the matter is left to the sound discretion of the disciplinary authority. This is the effective portion, my lord. It is made clear that in the event of taking any decision to reinstate the petitioner in service with any one of the lesser penalties, same will not entitle the petitioner back wages. The disciplinary authority shall now pass appropriate orders in terms of this judgment and order, and consistently with the observations made above as expeditiously as possible, preferably within 31/3/2011. Now, my lord, at page 37, if my lord, I could show the language. It says that on page, the 4th line, Shri Pranab Adhyapak, my lord has it, is hereby appointed as Fishery Extension Officer Fishfed in the newly created post in the scale of pay as mentioned in this notification. My lord, I have been in service since 1991. And now, with this appointment in a new position, what happens to my other benefits, my lord? I don't want the back wages, but my entire service record since 1991 just goes away. And this writ petition has been filed in 2013. Until date, my lord, no reply has come.
That till now, in all the petitions, nowhere I have found a reply. So you are not an exception. Now tell me one thing.
Yes, ma'am.
Come back to 36.
My lord, may I also be allowed to show one more page? In the order, my lord, page 36, which is the second page of the order. The last part, my lord. Previously as well, I was suspended once and then I was reinstated in service. And to the effect, they had issued these restrictions on me, which is on the last line. My lord has it, which will be the 3rd page of the order. The respondents have also brought on record the decision of the board. My lord has it. In its meeting held on 25/3/98, by which the petitioner was imposed with the following punishment: stoppage of 2 annual increments with cumulative effect, restriction of pay and allowance to the amount of subsistence allowance drawn during the period of suspension, realization of defalcated amount of so-and-so in 3 equal installments.
You are a habitual offender.
My lord, I would not exactly agree to that.
The order of the single judge also takes note of that fact. If you read it too.
To the unauthorized absence, yes, my lord. To that extent, I agree. And my reply may be.
We got it. You come to page 36,
Yes, my lord.
last paragraph.
Yes, my lord.
No opinion is expressed if independent, so and so, matter is left to the sound discretion. Now, it is made clear that in the event of taking any decision to reinstate the petition in service with any one of the lesser penalties, same will not entitle the petitioner to back wages.
Yes.
Two things. One, the order of penalty was not interfered with.
Yes.
So that continued. Right? Two, said, if you give her any other penalty, that period till which, if you reinstate her with that penalty, there will be no back wages.
Only back wages, my lord.
Only back wages. I'm only on that. There will be no back wages. Now, will it not be a break in service? Because the court has not said that it should be notionally fixed.
My lord, this order, if my lord, I may be allowed to see the termination order, please.
Where is that?
Termination order, my lord, is at page 17, annexure 2.
7?
17, 17. Then, my lord, there was a show cause notice to the effect at page 18.
It's
I was
12.
initially terminated. This is the order.
12.
Right. And then, my lord, I was issued the show cause notice, to which I filed a reply. They asked me to file a representation. I appealed before the appellate authority. Nothing happened. And this is how Justice B.K. Sharma's order follows. However, my lord,
I got everything.
if my
Now
lord
just
also
tell me the tsunami of that finding, the effect of that finding.
of back wages.
Back wages, penalty not interfered with, no back wages, impose any penalty. Now that means that period you are there, it's gone.
But my lord, even initially as you have just quoted that, as your lordship have just quoted me being a habitual offender, if my lord may see my submissions in the petition.
I'm giving you everything.
So there,
Just explain this line to me.
my lord, I can only say what I have in my pleadings. My pleadings say this.
I know you can say from the order only. We are only on the page 36. That is the key. Why I'm telling you, if there is a break in service, admittedly, then this order is not wrong.
My lord, assuming this is a assuming but not admitting this is a break in service, even before this incident, there was an occasion where I was suspended. They put me back into service and they reinstated me. The period of suspension was held to be as if I was in job and I was paid everything. So today, this order of termination, my lord, again, as I'm saying, assuming but not admitting, I don't think, my lord, it meant that it is a break in service.
We are not with what it means. We are with what it says.
Then, my lord, I will have to come back with...
At 2 o'clock.
I'll come back.
Prepare. Just clarify me on that.
I'll do that.
That's my interviewing, my lord. Actually, I'm sorry. Immediately, I made a false statement about that. They have not been promoted, my lord. That's now I have received a copy.
Okay. That makes my work more easier.
My lord. The first one is Mrs. Prabhupada, she has been promoted on my lord. First of July 2020. The other one on 1st of March 2018, my lord.
Oh, Mr. Dijan Seke has scored a march over you.
Well,
It way. 4, 5,
good.
2, 3, 9, 2, 3, 2, 3. Okay.
Extremely sorry.
No, it's okay. It happens because clients lost touch.
Item 11.
Yes, Mr. Bora.
Yes, Lord.
SFA Medico. What is it called?
SFA, it is Senior Field Assistant Medic.
Medicos.
So he wants to be posted because of selection.
Just what I understood. if it is correct, we can cut the time short.
Yes, your lordship.
He was under the LDCE select. You have the records with you, madam? You are ready with the matter?
Lordship, my senior is in
Who?
rights, Lordship. Mrs. A. Gayan, Lordship. She is coming, Lordship, in 5 minutes.
There was a LDC wherein you were found to be qualified. And thereafter you were shortlisted for that SFA medico, something, medicos
Appointment.
appointment. In the meantime, you were subjected to a departmental process. So you were not released.
For the
It-
second time.
Be that as it may. There was a first minor penalty, I think, and then a major penalty.
Both of them are minor penalty.
Minor penalties,
Stoppage of increment.
stoppage of increments.
For the same offense.
Now, finally, rightly, wrongly, you have been held to be guilty. You underwent that period. You suffered that penalty. All your pleadings, after that, all your written statements or representations, that now I have completed my
Penalty period.
penalty period, now give me the promotion. Now, should we permit you to make a challenge to the departmental proceedings at this stage?
Your lordship,
Or limit this writ petition to your that prayer?
your lordship will limit only to a prayer of appointment to the SFA medic.
See, don't make a offhand comment. Think and say.
Your lordship, I have
Both have its own consequences.
consequence. I understand.
Tell me.
First, your lordship, if suppose I have to challenge the disciplinary proceedings for the second time, in which I was actually imposed a punishment of withdrawal of increment for 2 years, 3 years, then lesson down. to
No,
2
one
years.
stage, 2 years.
First was 3 years.
That you forget,
then
that
I
is
went on
gone.
appeal, then it was reduced to 2 years.
One stage that earlier was reversion.
Reverse.
This is one stage,
One
one increment now
One more period
for 2 years
for 2 years
with cumulative effect.
with cumulative.
Hmm.
Now, for the same facts, I am only on the point here. I'm
No,
challenging.
first you decide whether you will challenge the proceedings.
Your lordship, I just had a word.
Then you will have to tell me, why didn't you, what is the delay for 2 years? Because you can't have both.
Your lordship, I immediately filed representation after representation. They did not.
All those representations, you have not even gone for a review. Because
No.
a review was permissible, you did not go for a review.
No.
You did not challenge it.
After that particular order was actually given by the appellate authorities. Just come to it.
Why go that far?
I just lost
You
my.
come to page 78. Come to page 81.
Page 81.
Yes.
That is the modified representation.
These are the representations which you gave.
Yes.
Seeking the benefit, and then you underwent the penalty.
Yes. Then again, I represented at page number 82, 83. Your
Ah.
lordship.
83, no, not 83.
Not 83 is not a representation.
There is a legal
Basically-
notice given,
Yes, sir. Basically,
2012.
2012.
So by this time, around
I was waiting for the.
4 years have gone.
Your lordship, the ultimately, in 2011. If I have to go
You
to
take a
page-
call, because if it is 4 years, you will have to explain. And those letters would come in your way, my view.
Yes, your lordship.
And
Right now, your lordship, as I had a talk with my client yesterday, because it's a long pending matter. So I asked him whether you want to be appointed now to the SFA medic, or you want to let go of your claim for the department proceedings. He said that I want to go for this appointment as SFA medic.
then we will direct them to consider your case under rules, because the earlier consideration cannot be given because there is a penalty.
Yes. Now,
Anyway, don't jump into conclusion. You come back after some time, think over this.
yeah, your lordship, in fact, if I take your lordship to the page number 83.
Hmm.
After he was actually, his punishment period was over.
Hmm.
Consequent upon completion of currency period of punishment awarded to number so and so, his pay revoked from so and so in the pay with great pay of 1800 has been restored. Now, your lordship, the only contention that they have raised in the counter affidavit, if I have to take your lordship to the counter affidavit, now why I cannot be appointed
if I have to take to page number 15, para number 27. If I have to read out your lordship, para number 27, with regard to the statement made in paragraph number 33 of the petition, the deponent.
They say that the panel is not there.
That is not a valid point.
Not a valid. I'll give a better reason.
Because yesterday I found one particular OM of the POPT.
On the point?
On this point of validity of a select list of a LDC examination. What is the validity period?
We will not go into that, Mr. Deepam. Why should I go into an OM when there is a Supreme Court judgment against you in this context? KV Janaki Raman.
Janaki Raman, with regards to that particular fact also, Janaki Raman also, it is with regards to the currency. After currency of the penalty
it
period.
says seal cover, we'll hold it as a seal cover.
Yes.
Seal cover will not be opened if you have been imposed with a penalty.
Yes.
Finished.
After currency of the penalty period, he may be again considered for.
He can be considered, but not in terms of that. There has to be a fresh consideration.
Fresh consideration.
That we can direct. You know? I'll not write a long order. Mr. D. Bora, learned counsel for the petition. Heard Mr. D. Bora, learned counsel for the petitioner. Also heard Ms. A. Gayan, learned CGC, na?
Yes, madam.
Appearing for all the respondents. So, Mr. D. Bora at the outset submits that he is limiting his prayer in the present proceedings for a direction to the respondent authorities to consider his case for promotion as SFA
Medic.
MEDIC, na?
Yes.
Medic. Full stop. Only. And the prayers as made in the writ petition be molded to the above extent. Full stop. The facts requisite for the purpose are noted here in below. The petitioner was subjected to a departmental proceeding by issuance. Just tell me the facts if I'm anywhere wrong.
Yes, sir.
By issuance of a memorandum dated 26/2008, wherein two charges of misconduct came to be, two allegations, wherein two articles of charge came to be framed against the petitioner. The said proceeding culminated in an order of penalty, in an order issued by the disciplinary authority, imposing upon the petitioner a penalty of reduction to a lower stage in this time scale for 3 years. So, the petitioner thereafter assailed the said order before the appellate authority, and the appellate authority wide order dated 1/6/2009 on consideration of the matter was pleased to replace the penalty imposed by the disciplinary authority as reduction to one lower stage in the time scale of pay for the revised reduction to one lower stage of time scale of pay for a period of 2 years only by reducing the pay from 6,410 to 6,170 only in the prescribed pay scale with cumulative effect from 1/6/2009. So, it is seen from the materials available on record in the writ petition that the petitioner, on completion of the currency of the said penalty, had approached the authorities paying for his appointment against the post appointment. Full stop. At this stage, it is to be noted that prior to the initiation of the departmental proceedings against the petitioner. The petitioner had qualified in a limited departmental competitive examination held for the post of
SFA
senior
field assistant.
senior field assistant bracketed medical. And he was empaneled for such promotion. However, such promotion was not effected on account of the initiation of departmental proceedings against him. So, the petitioner, after completion of the currency of the penalty, had approached the authorities praying for affecting his promotion in terms of his selection made prior to the initiation of the departmental proceedings against them. The said representations having not been considered by the respondent authorities, the petitioner had instituted the present proceedings. Also, as noted here in above, the petitioner has noted here in above, the selection and appointment of the selection of the petitioner for his appointment as senior field assistant medics in the year 2008 cannot be given effect to on account of the fact that there was a departmental proceeding initiated against the petition approximate to the point of time of such selection, and the petitioner having been found guilty and imposed with penalties, the said selection cannot be now given effect to. Full stop. However, as prayed to by herein above, as prayed herein above by the learned counsel for the petitioner, in the event petitioner still fulfills the requisite eligibility criteria for being appointed as SFA medic, his case cannot be denied to be considered on account of his having suffered penalties pursuant to a departmental proceeding. The penalties, the currency of the penalties having already expired, there is no bar for consideration of the petitioner for promotion, for recruitment as SFA medic. So, accordingly, the petitioner is required to submit a detailed representation before
For the respondent number. Respondent number 2, he was posted there.
No. You go to a higher authority.
Respondent number 2 itself, Your Lordship.
Respondent number 2.
Respondent number 2 itself.
2. True proper channel, but
True proper.
Respondent number 2, true proper channel. Laying is praying for his promotion as SFA medic. Also, on receipt of the said representation by the respondent number 2, the same shall be given its due consideration, and on following the procedure as mandated, the case of the petitioner be considered for such promotion, and if he is found to be eligible and qualifies in this election, his appointment be his promotion. It will be a promotion. Promotion as SFA medic be effective. Also, however, it is to be noted that the authorities, while considering the case of the petitioner, shall not reject his case on account of the penalties imposed upon him earlier, the currency of which now no longer exists. With the above observations and directions, the petition stands and disposed of. I think that will do.
Yes.
The press consideration.
Fresh. That is gone.
Yes.
Item 12.
Lordship, may I pray that the matter may be taken up after some time, Lordship. My senior is on legs in court number 8.
We'll hear him by the time he can come. Or we'll hear him together. After some time.
At 2.
At 2, I can't guarantee because I've not touched my first list. I'll just go through that. That will not take much time. Then I'll come back.
Most of that. Most of that.
Item 13.
অলপ পিছত মাতিব আৰু।
Item 14.
Does it matter to be pass over for the time being because my senior is lex on court number 27.
Who is your senior?
Mr. A.K. Purokas.
But 2013 matter, we will not adjourn it. Call him. We will not adjourn this matter. We'll take it up today itself. Today itself.
Item 15.
Wait, please, Your Lordship. Lordship, in this matter, I'm seeking a short accommodation.
Give me a reason which is valid.
This matter might have become infructuous. And
Might have become infructuous, we will make it
Lordship,
infructuous.
we were unable to establish contact with the
Forget it.
petitioner.
15, 13 matter, if your client has not incorporated, fine.
Short.
It is that AW matter, na?
Anganwadi worker
Anganwadi worker. You are appearing for?
for the department.
Department.
For the
There is a stay order. She is continuing. If there is any misconduct, proceed against her. We'll close this repetition. Right? What is your name?
R. Chauhan.
R.
R. Chauhan.
R.
R. Chauhan.
Chauhan. You were appointed as a child development, as an Anganwadi worker. Then your services, you were terminated. You come up before this court, terminated in 13. You come up before this court, and this court, wide an order dated 13/5/2013, stays there. You're continuing.
I have to obtain instructions.
According to me, you are legally continuing. If you don't have instructions, that is your headache. I'll proceed with that.
Short.
We'll dispose it off. And if there is any misconduct against you, they will proceed against you legally. We'll interfere with that order. So anybody from private respondent? Oh, here is sitting so side. Yes, come to say. What is the situation in the field?
But I have also not.
Very good. Your client never got that post?
Not.
Fine, very good.
He's not communicating with it.
As your Lordship, please.
It was not me pleasing. 13 matters will not allow it to be adjourned. If your senior has anything more to add, he can come back. Otherwise, tell him the order is interfered with. Have you got the implication of the order? Your writ petition is allowed. Then what more is required?
Good.
Yep.
Item 16.
May I please, Lordship? Lordship, in this
Yes.
matter, I want to withdraw this upon the instruction of the client,
Why?
as the matter has become infructuous, Lordship.
She has got a pension.
No, Lordship, her husband has returned.
It's a very good thing.
Very good thing.
Even I was wondering whether.
I don't know why, yesterday reading the brief, I was just getting this feel that maybe he has come back. Because from 13, if this was the situation, there would have been some move to get the matter listed.
Exactly.
After 13, this matter was never listed.
Yes.
Heard, Miss
Yunanda.
Nanda, Learned Counsel for the petitioner, who submits, and also Mr. R. Dhar, Learned Counsel appearing for the.
My lord, I will appear for the state, my lord.
For all the respondents. You are appearing for the state housing corporation.
Lordship, I am for housing, Assam State Housing.
For
Board,
respondent number 1 and 2. And
3, 4, 5.
3, 4, 5
Lords.
by
TR Gogoi, Lords.
TR Gogoi.
TR Gogoi.
Sorry. Miss Yunanda submits that the issue raised in the present petition pertaining to release of the retirement dues of the husband of the petition to the petitioner has since become infructuous in as much as the said claim was made on the ground that the husband of the petitioner was missing from
9/3.
9/3,
2012.
2012. Also, it is submitted that the husband has since returned back, and accordingly, the said prayer has become infructuous. The writ petition in terms of the above stands dismissed as having become infructuous.
Much obliged.
Item 17.
An additional affidavit filed which I see.
Against
Some additional affidavit in reply. Mr. Monto, is there anything substantive in this which will require an examination? No.
Yes.
Yes.
Lordship may pass over the matter for timing, Lordship.
Why?
Learned Senior Counsel MK Sodri is leading us, Lordship, in this matter. He is unlike, Lordship, he is coming, Lordship. Lordship may pass over the matter for timing.
Timing means it will go second half.
Hello, can it be on tomorrow or day after tomorrow, my lord? Because what happened here in this case, the industrial dispute case, my lord. In industrial dispute, my lord, then labor court, my lord, without, my lord, go to the reference, my lord. They have taken evidence and they not all the evidence in the record, my lord. I have to gone through the record.
Okay.
Because what
The
happened
record I have gone through.
Yes.
The record it's there.
Yes, my lord.
And that is permissible procedure, right?
Yes, Lordship.
Under
And Lordship,
under permissible procedure under
Industrial Dispute Act, Lordship.
which section?
Lordship, brief issued. Lordship may.
Okay, we'll have it on.
So in the meantime, I will make a brief synopsis, my lord. I'll give it to your lordship.
That will be better. Both of you give me a synopsis with the
because-
legal points.
Because
His case is very simple. His case is the preliminary inquiry that was done, preliminary hearing that was done,
Lordship, only-
preliminary
that was held to be bad.
bad.
It
And
is
that-
not only the petitioner, Lordship, other employees also, they were also dismissed, Lordship, and they were.
What happened to the proceedings?
That was also dismissed. That was also challenged before this honorable court. The honorable court did not interfere with that.
Where are same reference?
Lordship,
Different.
same allegation, 9 against the giving money to the 9 fictitious person, Lordship.
Mr. Chaudhary has appeared. Timing.
Answering.
He wants to go through the records. Let him go through. We'll have it on 6th. Or we can have it on 1st also.
My lord.
1st. Mr.
Because domestic inquiry has gone. Domestic inquiry has nothing to do, my lord. Because domestic
That is
inquiry,
permissible.
that is held to be bad already.
Fine, that is permissible.
But yes, that is permissible. Now, my lord, labor court reappreciate and they have taken evidence.
Reappreciated
evidence-
means that you have also participated in that proceeding.
Yes, I have taken participate, yes.
On the prayer of Mr. T.J. Mohanto, learned counsel appearing for the petitioners. Lists this matter again on 1/2/2020.
Can it be 6, my lord?
Huh?
Can it be 6?
6. Okay. 6/2/2024.
Well,
Also heard Mr. Upot also heard Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. K. Kolita for the correspondence. Mr. Mohanto, it's permitted to
my lord, to go to the
permitted to
record will labor.
examine the lower court records during the course of the day.
My lord.
Lordship, union is also party. We are put a respondent 2 to 5.
For the M.K. Chaudhary, for the respondents 2 to 5. And
Union.
who is there? That will do. You are the main one. Okay. $15 থাকো 15 to dispose করে দিছো তো 18
Item 18.
second half of what one can do some
This time, by this petition, lordship, I had prayed for regularization of the petitioner, lordship. Two petitioners are there. They were working as master worker in Jagirod lift irrigation scheme.
After Upenda's lordship, perhaps she is entitled for the paragraph 22 of the Upenda's lordship.
Yes.
They were appointed in 86 lordship and on 94 they were temporarily appointed as works as helper. Thereafter lordship, they are working without
Why were your
break.
cases not considered in 2005 because of some?
Yes, lordship. They had not sent my necessary documents at that time. And because of their fault, lordship, it was not considered at that time. So similarly situated persons were considered.
There is a judgment of the Supreme Court, latest. I forgot. That if similarly situated persons have been considered for
Yes,
regularization,
Similarly
then
situated persons.
their case also has to be considered. Justice Procedural judgment.
They are left out.
Mr. Chaudhary, you remember that judgment? So you remember that? Regularization, no, both Chaudharys. He doesn't know. He small matters, Mr. Chaudhary will not know. There was a judgment. There was a judgment. Anyway, this is your case.
Yes, lordship.
List this matter again on 29/1/2024 as a part head matter. Let me see if I can get it.
Lordship.
If not, Upendas.
Lordship.
Item 19.
Here, my lord.
Yes.
The law is otherwise, but your lordship is aware, higher qualifications can always be prescribed. But here what they have done is, they have
Computer.
beyond the rules.
Give me a judgment to that effect. There are judgments of Supreme Court that if you go beyond the rule, that would be.
There is one that 2021. And here, my lord, the other interesting thing is, Assamese is prescribed in the rules, they did not allot any marks. And computer is not prescribed in the rules, they allotted marks and also.
Stand of the APSC is.
APSC has.
It's wrong, but what to do? That was come, so we have done.
And the next round of selection, they again omitted.
And you came in.
That is where I came in. So here, my lord, in any case, the respondent number 5, he did not accept the appointment. He joined and he left. So no prejudice would be caused to anyone. And otherwise, I'm working in the same position. The only
thing is that you will get an accelerated seniority now.
No, I will get an earlier date.
Of seniority, you will get an earlier date.
And a little bit of maybe pecuniary benefits.
That we will not give you.
Your lordship will kindly have a look at this matter. 2021 15 SCC 501.
2021
15 SCC 501.
Read that relevant portion.
This is Justice Nageshwar Rao and Aniruddha.
Page.
Page is 501.
Para?
Relevant para is 34.
What is the name of the party?
This is Kerala Public Service Commission versus K.N. Radhamani.
Oh, yes.
And this is what it says. If an advertisement is made providing for eligibility criteria different from that statutorily prescribed, it would be open to the candidates to challenge the legality of such eligibility criteria. Basically, you can prescribe higher qualifications, but you cannot go beyond the rules. And admittedly, my lord, by their own conduct.
Knowledge of computers is the prescription, but it became a game changer.
And the other
private respondent left now. You had incorporated one more private respondent.
There are two, but the respondent number 4, Jayanta Bora, he joined and he left.
Okay.
So that against that vacancy, they can very easily adjust me.
This Nina Borua?
Second open category candidate. There are two open category candidates. One is Jayanta Bora, one is Nina Borua. Nina Borua was implemented as a party lordship on their pair lordship.
She has not come.
She has filed. My instruction is that she has filed a wakalat, but has
Who
not
is the
appeared.
advocate? Is it reflected?
There are two names shown in the cause list.
Mr. B.K. Das, Mr. H. Cook. Okay, this is
That is the only point.
yes. What do you say? You give me a list of the short synopsis with your judgments, paragraphs. Don't bring Madanlal and all those things. That's not required.
Not,
They only on there are more judgments you will get. You just make a search. Yes.
Lordship, this is my stand in my affidavit in opposition. That APSC has queried the government. whether,
Query did not. Incorporate this APSC part also in your.
yes, it is part of the record.
No. In your that synopsis.
Mal.
And who is appearing for the government? Yes. APSC, that is the thing.
Yes, that is it.
50 marks you have given for that because
Yes,
of that.
Lordship. And
45 interview.
one more Lordship argument from my side.
Hmm.
That prescription was given prior to that, along with the advertisement. He participated.
He did not challenge.
He did not search. And it has not prejudiced none, Lordship. Everyone knows it. And regarding that, accommodating the petitioner on that post left by Jayanta Bora, as per FRBM Act, Lordship, whether it can be given or not, I have some doubt, Lordship.
One thing. First argument is
He concisely participated, Lordship,
without challenging the.
without challenging.
No, at that time, it was never indicated that they will be allotting marks.
That plea you have already taken in your reply.
Yes.
That was the first thing I searched for. Second point?
The second point, that knowledge of computer application.
No,
was
Jayanta Bora.
Jayanta Bora.
Bora joined.
Jo-
He
Joined
joined.
and left.
Jayanta Bora.
Then,
Join and left.
then that becomes a fresh vacancy, Mr.
Lordship.
Chaudhary.
This is my,
No, it was within the validity of the select list.
If he joins,
join, Lordship.
that select list goes.
But if, assuming
Page
the
64.
select list would have been operated, they could have still filled it
No,
up, which
they
they
could
did
not have. They could not have. There is a judgment. They could not have. Once a person, if he does not join, say, I don't want this, I'm going, then that post remains vacant. The moment he joins and then resigns, it becomes a future vacancy. It's not a vacancy of that selection.
I'm not in that context, madam. I'm in the context of, in the event your lordship decides to allow the repetition, your lordship can always judicially direct it. Your lordship can say.
Now
that
tell
it
me
is-
one
it
thing,
is-
one thing, one
It
thing.
is
no.
merely a technical adjustment that they will have to do.
Mr. Chaudhary, is there a select list with marks on record?
Which marks no?
So your claim that you are the next candidate,
No,
how do we come to know that?
no. My contention is that
There may be other candidates because of this who are just above you.
the, in the event, but none of them have come forward, number one. And secondly, my entire contention is that only by including computers, which is not part of the rule.
We will say that that is wrong. But to direct for your appointment,
Your lordship will
how
kindly
will there may be hundreds appearing for this selection process.
possible.
Hmm.
On that matter, my submission is twofold. Number one is none of them have at any stage raised this grievance similar to mine. Number one. So therefore, we do not know, they might have accepted it as it is. That is number one. And number two, since I have already got an appointment in the same cadre pursuant to the next selection process immediately within 1.5 years, it will be a case of a mere technical adjustment.
No, why I'm saying so? Moment I touch that first one, I'm reviving that list. Technically,
In that case, well, perhaps the next option would be your lordships will have to tell them that if in case this affects anyone else, their cases also would be considered.
okay. When can you give me that written note?
Next week,
No, no,
only thing is 2 days.
this week, Thursday. Friday, Saturday, Sunday is my drafting days.
Well,
okay.
He will give it, madam. I may not.
You
be
need
able-
not be here. And Mr. You also give me one.
Lordship.
And therein, if possible,
Lordship.
if you can get me the position of the petition.
Lordship, she was 8th position. I have the record, Lordship, as per direction.
Okay,
Eight.
you give me a tabular sheet of that.
Yes, yes.
Whatever is there, you give me.
I'll do.
Just don't give me the records, make a tabular sheet.
Lordship, I'll do.
That takes care of.
Mr. If I have a little bit,
If he can furnish the list with the mark,
Yes.
that takes care of the problem. Because
Let me see.
your lordship will have to simply direct that if anyone is above me, their cases also will be considered.
No,
That solves the problem.
no, not considered. Let me see what I can. Just one, no. When can you give me Thursday? Thursday, or if you want, I can put it on Monday, 29. Monday. The party settling, so naam likhi lo bude. List again on 29/1/2024, on which date the parties are permitted to bring on record their written arguments along with the relevant decisions. So, no more hearing. This is it.
Okay.
And I'll only think about that. So, Chaudhary, we'll just finish up the motion matters and then come back. For part one list and then come back to the hearing. Admission, we'll come back.
Tally list for motion item 21.
Tribal education. The tribal education matter.
My lord, that Ecolabo Model Residential School matter.
Where is Mr. Thar? Yes, what is your stand now?
My lord, my stand is, my lord, I have gone through the various notification and guidelines, my lord. And in that guideline, my lord, I have not found the word approval, my lord. Approval is not required, my lord. And we have gone through the guideline, and guideline says that the chosen, the committee is required to be chosen by the government.
By the government.
By the government, my lord, if we go by the language of the guideline, my lord.
Show me that, show me where it is.
Yes, my lord, if just for a moment, my lord, is at page 52, annexure 1.
52.
Page 55 is relevant, my lord, my petition.
Yes.
A management, my lord, I am reading page 55 clause Z, my lord. A management committee may be constituted for each Ecolabo Model Residential School, which could include, among others, reputed local NGOs involved with education. Help of such NGOs may be taken to organize socially relevant development of the welfare extension programs. The task of school admission, appointment, so and so personnel, and to day running of the school would be handled entirely by the society chosen by the state government and the union territory administration, and in the manner deemed most suitable, my lord. Now, my lord, in what manner this society are required to be chosen? That has not clearly explicit in this guideline, my lord. And therefore, my lord, this committee, my lord, long back had been, my lord, allowed to operate by the government.
Show me that.
My lord.
Show me that.
No, my lord, the action of the government directly, my lord, there is no order at the initial stage.
How can somebody on a word of mouth do it?
No,
There has to be something.
Yes, my lordship, I can understand my lordship's query, my lord. On the strength of the verbal or any such action of the government, my lord, we cannot say that is the chosen part has already been over. Now, my lord, the subsequent action, my lord, which has been allowed by the government, subsequent actions, my lord, which has been allowed by the government, and in the various inquiries, my lord, which has been conducted by the government regarding our status. My lord, one thing is here, my lord, the committee is not here before my lordship, my lord. That is another difficulty, my lord. Because, my lord, we have also not made the committee as a party.
That's what I pointed out the other day.
My lord, if my lord allows us sometime, my lord, we can bring the committee, because my
That
lord,
you
the
do it.
committee is the appropriate authority. My lord.
What we do is,
My lord.
in view of the fact that this matter would require further consideration.
My lord.
We will consider the matter.
My lord.
We will permit them to run the school because the children's welfare is more.
That is the difficulty, my lord. That is what I am submitting, my lord. We are already in service. My lord, may kindly see a letter, my lord. Kindly see a letter.
No, my lord.
I am bringing my lordship's kind notice to a letter, my lord, the inquiry report which has been prepared by the inspector of schools cum principal of the college, my lord.
Where?
Affidavit in reply, page 356 to 358, my lord. 358, my lord. Demand page क्या हो? Now, my lord, the last paragraph at page 358, my lord, I am saving my lordship's precious time, my lord, paragraph 12, my lord. Paragraph 12, it may be mentioned that as per the
Page
letter,
358.
my lord, I am reading page 358 of my rejoinder affidavit, my lord. My lord, it is very difficult, my lord, nowadays running.
No,
pages are-
there are two numbers given here.
My lord, it is an inquiry report which I am relying, my lord, inquiry report
358.
dated.
Wait. I'll
Fine.
just go by your marking. Yes. 358, yes.
My lord, 358, the last paragraph I am relying, my lord.
There are 12.
Para 12. May I read, my lord? It may be mentioned that as per the letter by number so and so dated dispute the 12th November 21, addressing to the Deputy Commissioner Baksa, the recruitment rules of the teaching and non-teaching staff under the Ekalagba Model Residential School formulated by the Ministry of Tribal Affairs, Government of India, copy and close so and the Government of Assam, minutes of the meeting held on 6th of June 2019 under the chairmanship of the Secretary to discuss the issues relating to the EMRS Dalbari Baksa. And after the threadbare discussion, the following decision serial number 7 was also taken as the EMRS
This
Society.
is by some in-charge principal Ekalabia Model.
My lord, he is also the inspector of schools of the Baksa district, my lord. This is a proposal, an inquiry report prepared pursuant to a direction, my lord, detailed present report of the Ekalabia Model Residential School, Dolbari Baksa, prepared basing on a letter dated at page 355, my lord.
Show me your appointment orders after this.
My lord, the appointment order, my lord, may be pleased to find.
What is the date of this report?
My lord, date of this report, my lord, is report to kiti asile date ko next paragraph. My lord, 7th October 2023 is the relevant letter by which this report has been communicated to my lord, Secretary to the Government of Assam. My lord, may be pleased to verify from page 355, my lord. 359, my lord. 359 is the, my lord, to the, my lord, Director of Education, BTC, my lord. This is
Okay.
my lord.
Now show me your appointment.
Yes, my lord, may be pleased to find our appointments, my lord.
So this is the proposal, as we can understand.
My lord.
Clause 12, that the appointments now would be done
my lord,
by the society, ERMA society, as per Right to Education Act 2009.
My lord.
So this is a future action.
Future action, but
Show
my
me
lord,
that. Show me your
my
appointment.
lord, our process for regularization has also been taken care of, my lord.
You show me.
My lord, my appointment order starts at page 130, my lord. Additional affidavit, my lord. No, it is running as a page 130, my lord.
Additional affidavit filed by you.
Yes, my lord, it is starts at page 130, my lord. All the petitioner's appointment I have annexed, my lord. Up to page 100
Okay.
My lord.
129.
28th of June 2013, my lord.
So how can this be in relation to the report at page?
Yes, my lord. That relation, my lord.
401.
Yes, my lord. That relation, my lord, may be pleased to find.
No. You just be here. 401 and 129.
My page.
What is the correlation?
My lord, my
because
page.
this is of 2012 and this report
My lord.
is a future course of action in 2023 October.
That is correct, my lord. My lord, may be pleased to verify page number 81.
Of your petition.
Yes, my lord, page number 81.
Yes.
This is the, my lord, these are the staff.
That
my
is
lord.
by your, that society.
Yes, yes, my lord.
So
Society.
we come to page 129.
No, page 129, my lord, we are not disputing, my lord, that the appointment which has been made.
No, sorry, not 129.
358.
It is 130.
130 is also the appointment order, my lord. This is a, my lord, we cannot deny that this is an appointment which has been made by the, my lord, Boruland Tribal Education Society.
And you are trying to justify that
My
with this information. We'll consider this.
My lord.
We'll consider this.
And my lord,
And we will protect your rights also, don't worry.
my lord, till
In the
date,
final analysis, if we come with you, but we can't let this student suffer.
the student is not suffering. We are
Suffering,
working,
my lord.
My lord,
How
kindly-
can you
my
be
lord,
there, Mr.
My lord.
Mr. Bhia, how can you be there?
No,
You
my lord,
cannot be
My
there
lord, they are
because
not there
that
now.
society is gone now.
That
my
is
lord,
gone.
My lord, what I am
The
submitting-
society who had brought you in,
My lord.
the agreement is with the society. Come to page 130.
No, that is, my lord, page 130 is the appointment order issued by the
Okay.
society, my lord.
Yes,
My lord,
Mr. Dhar, what is your case?
My lord. My lord, the first thing is that, my lord, I'm just going to my affidavit.
Forget it. Tell me who is
Page-
running the school now?
School, my lord, we are running it, my lord.
How?
My lord will see page 186. By this, my lord, WPTBC department now, it's called Tribal Affairs. They have come into action, my lord, because they are now the registered society for the Ecolabo Model School. This is 100% central government funded scheme, my lord, run by, now it's run by this WPTBC Tribal Affairs Department as of today. So, my lord, so it is now us only, my lord, we will do it. And my lord, the society, which in our affidavit, we have contended that they are encroachers. They forcefully came in, my lord, they tried to grab the building. When we came to know, we have taken action. They have been
They have given up.
given up everything, my lord. Now, my lord, the thing is that since we have taken over the control of the school, this is our money we are spending. So, my lord, we have to recruit new teachers.
It will be contractual.
Guest teachers, my lord, in fact, now.
Guest,
Guest teachers,
not regular.
not regular. Guest teachers, my lord, so that the children, at least they get this education.
Mr. Bhia, they are guest lecturers.
Guest teachers, my lord.
We are
That is
permitting
the
them
advertisement
to
all about.
go ahead with the recruitment.
My lord.
But Mr. Bhia, without this being finalized, your rights will not crystallize.
Yes.
There is no right. It's just you are, as he used that word, encroacher. Your original society was an encroacher.
That is
We will
not-
have to go beyond that.
My lord,
I'll protect your rights. Let the students' interests be protected. Let them go ahead with the recruitment process. They will, in the orders of appointment, reflect those appointments are subject to further orders of this court.
Exactly, my lord.
My lord, may I submit, my lord? My lord, my respected senior friend has said that they are going to recruit the guest lecturer.
That is the advertisement says, my lord.
Wait 1 minute. You also, if there is an advertisement, you also participate.
No, participate.
No,
What is there?
that is the issue, my lord. Now, who has issued the advertisement? My lord, if I am wrong,
Who has issued the
who has
advertisement?
issued the advertisement? That may kindly be verified.
Advertisement has been issued, Mr. Dhar? I don't think so, because I did not find any second advertisement in the record.
Society is required.
Society is one, the department, my lord, WPTBC.
That I am satisfied.
No, my lord, so there is no society.
My lord,
They have
we
registered a
registered-
society.
No,
certificate
my
we
lord,
have given, my lord.
kindly pay.
Okay. Okay, we'll. You have issued an advertisement?
That advertisement kindly be verified, my lord.
You have issued an advertisement, Mr.
My
Dhar?
lord. That is what
You
is
do one
under
thing.
advertisement.
You
I
just
am
get hold of that advertisement. We'll take it up after a few minutes. Okay, Mr. Dhar?
My lord.
Mr. Dhar,
My lord.
you get hold of that
My
advertisement.
lord.
Follow up, Mr.
Item 22.
As per last order, my lord,
Yes. Who is
Yes.
there for the
elementary.
elementary? That cancellation of the select list.
Include, my lord,
at page 101, my lord.
Heard Mr. B.K. Pukastov, learned counsel for the petitioner. None appears on behalf of the Elementary Education Department.
My lord, sorry.
What happened? What is your instructions?
My lord, I can.
Item number
22.
22. Ms. Shutia was supposed to take instruction.
For time being, my lord. Man.
Supplementary list, item 48 for motion.
May I please, your lordship? This case, your lordship, we have put to challenge, the petitioner has put to challenge, your lordship, an order at page 35, your lordship, by which, your lordship, he was deployed at a different school, your lordship, although he is presently working at in a
You have around 3 years service left.
lordship. And your lordship will kindly see, I raise a grievance, your lordship,
With regard to the.
appointment of the principal.
Now tell me,
IT.
Mr. Pothakur, one thing. How
Lordship.
far is this school from the school, government high school?
This is your lordship.
And this school, where is it
It is
situated?
in Kamrup district itself, around 16 kilometers.
Kamrup Metro?
Metro, your lordship.
Where? Patoguri is where? Patopuri.
Bathoguri is near your lordship, that side, your lordship, Lokhara. Issue is not that your lordship distance.
Now, why my only doubt remains,
Lordship.
they have instituted a Bodo medium higher secondary school.
Lordship. I understand, your lordship.
And it's not only you who have been taken up,
Lordship.
but another 2 have also been
Lordship.
taken up. If it was only you, we would have had a doubt.
Lordship.
But there are 2 other persons also.
Maybe your lordship.
And by going by the name, maybe they want people who can speak Bodo language in that school,
Lordship, ultimately.
which may
your
not be readily available in this city. Bodo teachers of this status may not be readily available. Is that the reason why they have?
In fact, your lordship, I have asked him, your lordship. He has said, your lordship, that during all these years, your lordship, he has, your lordship, taught in your lordship in Assamese medium schools, your lordship.
Okay.
And there is no occasion to your lordship to teach this school also in Bodo medium, your lordship.
Yes, Mr. Sharma. What is the reason behind this?
My lord, kindly come to the page 34, my lord. It will further be pertinent to mention here that the aforesaid 2 office memorandums have never been circulated during.
So this
my
is the
service
reason why
period.
you issued.
Therefore, the content of office memoranda are not within my knowledge, my lord.
Okay, fine, we got it. Is this the reason why you have issued 35?
No, my lord, actually, by passing the, my lord, by passing the authority, he has
I
made
got
the
it, Mr.
complaint to the
Sharma.
chief minister.
I got it. I got it. Is that the reason why the order at page 35 is issued?
No, my lord.
Then you get your instructions.
Yes, my lord, I will.
On the next date fixed. You have not been released.
Not yet, your lord.
On the next date fixed, Mr. Sharma, Learned Counsel for the Learned Standing Counsel, Secondary Education Department, shall place on record instructions as to why, as to the reasons behind issuance of the impugned order dated, of issuance of the order dated 12/1/2024, temporarily deploying the petitioner who is presently working as postgraduate teacher, PGT, in Dispur Government College to Hatau Puri Bodo Higher Secondary School, page 35. Okay? Page 35 for so and so, full stop. It is submitted by Mr. Pothakur that in pursuance to the order dated 12/1/2024, the petitioner has not been released from his services in Dispur Government Law Higher Secondary School. Full stop. Till the next returnable date, the status quo will do.
Lord.
The respondent authorities are directed to maintain status with regard to the service of the petitioner hearing. Also, list this matter again on 12/2/2024.
Lord.
Or we can We can give you an early date if you want.
No.
9/2. 9/2.
Lordship. Deeply obliged.
Daily list for admission, item 23, quarter.
We'll have it after some time. no?
Yes.
Only one thing, my lord. My lord, Dr. Kondrapo Das's name, my lord, has been reflected in number of pages. The appointment is during his tenure. And your lordship may not like to pick up the matter. Page 35, page 70, page 71.
I don't understand. We'll see when the matter is taken.
Dr. Kondrapo Das, my lord.
I'll see. I'll see. Dr. Contropodas had appointed him.
My lord.
Contropodas had appointed him.
My lord. And in view of that, the illegal appointment orders, the UGC has directly written to the authority.
Sir, I pointed this out last
The
week.
inquiry report also reflected. At
Mr.
that time-
Chaudhary, I filed to you.
I'm sorry, my lord.
Mr.
Okay,
Pukan
then I
has
could not point out.
taken a plea that your appointment was made by one Mr. Kondorpo Das. Right?
My lord. Page 35, no inquiry report. First page. And page 71 and 72. 70 and 71. This is communication.
Where?
Page 35, my lord. The inquiry report. Of the
Now, where is the name that, where is
My
that
lord,
appointment? of?
Fourth para, my lord. Last line. Last but one line. Page 35. Unqualified professor appointed during 2021 by Dr. Kondorpo Das, the then Vice Chancellor of KKSSOU, Annex 4. Now, page 70 and 71. Affidavit filed by the university. The subject. This is communication. Dated 27 March 20.
Mr. Chaudhary, maybe I should not be taking this up because I had appeared for Kondropotas.
My lord, the Kondorpo.
Anyway, he has taken a.
No, this is a plea there.
I know that. I know why he has taken that. I know he has taken
His
that.
role does not come into
No,
here.
I don't have any objection.
No. Once you have taken up a plea,
I don't have any objection.
I'm not.
No,
I have
you
enough
have no
matters with
objection.
me.
Why did
There is
you
no
raise
problem.
this?
One or
As
two
a-
matters
as
I
a
can
court
take up.
officer, my lord, I
So
just
why did you
pointed
raise
out,
this
my lord.
question?
No,
Why
I
did you
don't have
raise
any
this?
objection.
If you had no objection, you should not have raised it. Once you
He
have
has
raised
raised
it,
it with a purpose, my lord. He has
there
raised
are
it with a
there are other
purpose.
courts here. It's not that this is the only single court, and I also have enough matters with me. Anyway, but this is not done. If you had to take it, you should have taken it last time itself. This is not appreciated, Mr. Pukan. Anyway, Mr. Chaudhary, I think I should not be taking it up. Once an objection in this manner is taken up, why should what is my headache in doing this?
I
Nothing.
think, my lord, as a court
understand, my
officer,
lord.
I should.
Today, when the matter was the matter was heard at length on 11/1/2024 in the presence of Mr. P.J. Pukan, Standing Counsel, Guwahati University. Also, today, when the matter was again listed as a parted item, Mr. P.J. Pukan has raised an objection in the matter by pointing out that the petitioner herein was appointed by one Dr. Kondorpo Das, and as such, this court may not like to take up this matter. Also,
My lord, if your lordship insists, my lord, I am
My
withdrawing the
objection will be, my lord,
in
recorded.
view
objection,
of the
my lord.
said submission made, list this matter before full stop. The said submission could have been made on the last occasion itself. However, full stop. Be that as it may, list this matter before any other bench without me.
My lord, my objection will be recorded, my lord. That he is doing it for purpose to delay the matter.
I have, I think, indicated enough.
My lord, as a court officer, I should point out, my lord. it is
I would
not
have
for
appreciated if
delaying
you
the
had
matter.
pointed out last time, because this thing you know
Lord,
from the last occasion also.
My lord, it did not occur to my mind, my lord. Hence,
Anyway.
my lord,
Earlier the better.
my lord.
But please don't do this. This throws an insinuation on me. I'll not take nothing for me, but at the outset, if you tell me, I'll allow it.
That is why, my lord,
I think that's the normal rule I can expect. Anyway, fine.
your lordship will see the order sheet, my lord, how many adjustments they have taken on what grounds, my lord. Every day, my lord, there is a new ground to defer the matter.
My lord, I will have to withdraw the statements, my lord.
No, no,
My lord.
no.
Or
What is
otherwise,
possible?
I will have to recuse from this proceeding.
You
If
please
you-
do whatever you, I have recused, you also recuse. It happens, Mr. We can't help it.
Earlier, doesn't occur, did not occur to my.
Fine, I accept that.
Item number 24 and 25.
In this case, my last occasion, my lord, Mr. Mozumdar will submit the instructions regarding what action has been taken in respect of my appointment is concerned, my lord.
Yes, Mr.
Well,
Mudra,
without further ado, I think with that order passed in December 2023, the director's order, that director's order says that it is without touching his services. So impliedly, perhaps that his services are
we don't want implied, we want.
because, my lord, I could not get a written instructions on this.
You have your
She
written
was on
instructions.
leave.
On the
yesterday.
prayer of Mr. R. Mujumdar, learned counsel appearing for the Department of School Education, list those matters again. How far? How long will you take for you?
We'll have it on Monday. I can have it.
No, Monday.
My lord, after 8th, my lord, my
We'll
senior
have it on 12th.
12th, my seniors come 8th, my lord.
Or 12th, board is, board fixed. We'll have it on 19th.
My lord.
19 to 2020.
March
19. Item 27.
May I please your lordship? Lordship, in this matter, PTCS, you can time lordship to file affidavit lordship on the last occasion.
Yes.
Lordship, I have signed the affidavit for signing, lordship, if allows me a week's time.
Mr. B. Chaudhary, learned standing counsel said, submits that the affidavit on behalf of the respondents in the matter is ready for filing and would be filed within 3 days.
Lordship, I will a week's time, lordship.
Within 7 days, full stop, accordingly. List this matter, a full stop, accordingly. By affording a last chance to the respondents to file their affidavit, list this matter again on 21 to 2024.
Item 28.
Deeply obliged.
Last occasion, the lordship decided to close this matter. My learned friend in the education department has submitted the instruction.
Yes, Mr. Vian.
My lord, on the last occasion, my lord, my learned friend, Mr. B. Kaushik has brought on record, my lord, that Rule 29 had been invoked for the purpose of relaxation that 10 years continuous in service. And, my lord, in respect of in the present petitioner and the respondent, my lord, that was missing in the list. And my friend, my lord, on behalf of the private respondent has submitted before my lordships that, my lord, due to some litigation, they were left out. That's why, my lord, that my lord, relaxation could not be provided in the list, my lord. Now, my lord, the data part, my lord, if we go by the provisions of the rule, that the recruitment in Rule 14 of, my lord, 2018 rules, my lord, it has been explicitly said that in what manner this, my lord, recruitment is required to be carried out. Whether, my lord, that procedure has been followed or not, that is also, my lord, not brought on record till date, my lord. Only, my
What
lord,
procedure?
basing on the seniority, my lord, I have to admit, my lord, that the private respondent is in fact is senior to me. But, my lord, basing not only the seniority, my lord, other criterias are also there, my lord, that the whether those criterias and the
It's your writ petition?
My lord.
Show me the pleadings of that
My
so
lord,
that I can understand exactly what criteria was not followed.
My lord.
Okay, this is that case wherein you have been appointed. His case is you don't complete 10 years, so you cannot be. Then you had brought on record minutes of a meeting of a selection committee, wherein they had relaxed that. But now Mr. Kaushik says that it was done because in your case, maybe it was not done as there was something. But you have brought on record, he has also brought on record an approval of the government.
Yes.
About your appointment. That's the case. Yes, Mr. Wayne.
My lord,
Para-
in fact, we have pleaded, my lord, in page 5, paragraph 5. Paragraph 5, my lord, that the director of secondary, my lord has got, my lord, page 5, my lord. Has a regular headmaster of so and so, the impugned selection was shown to be recommended by the state selection board by and the government of Assam secondary education, according to the approval by letter number so and so. That begs to state that the other annual confidential report, paragraph 5 and 6 is a my lord, little bit of pleading is here, my lord, regarding the, and in the ground part, my lord, at page 7.
Yes.
My lord. That, my lord, even then, my lord, that the, as.
No,
this is
no,
the
tell
topic-
me where para 5 is not an irregularity.
No, my lord, it is not specifically said, my lord, specifically said, but the, my lord, the procedure which they have relied at rule 14 is the provision of the
You-
law,
you
my lord.
show me how that procedure, what is your pleadings to that effect? Because you participated in the selection also.
No, I participated, my lord. I participated, but the, my lord, that has been, as I have not been given the appointment, my lord, the other criteria which they have followed or not, in what manner
That
the,
he also will not know because after the selection, he is also not involved. So for that, you will have to have a specific pleading
my lord,
that this is the provision which they have not followed.
followed, yes, my lord.
What is it? We will have it on Thursday. You
My-
formulate.
my lord.
Okay, we'll
My-
pass orders. On the prayer of Mr. K. A. Bhia, list this matter again on 25/1/2024 as a part of it.
Obliged.
Formulate. What is it?
My lord.
Item 29.
May I please, your lordship?
Yes. The affidavit of the BTC is on record.
Yes, your lordship.
Where is the affidavit of the BTC? It has been filed.
Yes, your lordship. They have filed it on your lordship.
I have filed our affidavit, your lordship, on 11/12/2023,
11/12/2023,
your lordship,
On behalf of BTC.
on behalf of BTC.
Okay, okay. So we'll have to hear this matter now. Right? The pleadings in the matter are complete. Heard Mr. Soblikilova. Pleadings in the matter are complete. Accordingly, list this matter for admission hearing on 6/2/2024. An endeavor would be made to dispose of the matter on that day.
I am for respondent number 6 and 7.
You just give it.
Yes, yes. Much obliged.
Keep your legs.
We'll hear it on 6.
Item 30.
28, 29. Adjourn. Adjourn. Okay, okay. Yes,
Procedural. My lord, my case is in a very short.
Ah.
So what happened, my lord? I have a my lord institution. I pharmacy. Hamas College of Pharmacy. That my lord. I apply. I have got the affiliation approval from the PCI to start the college, and it has been given up to 2001, 2002, and 2000 up to 2004. Then my lord, I started the institution. Then the question of affiliation arose, my lord. I applied for it. The government says in the affiliation, no application certificate is necessary from the government. So my humble effort will be, there is no necessary and to give the NOC for giving affiliation to the institution. First of all, my lord, inspection has been made by the concerned authority, and they have said that it is permissible. This institution can be granted affiliation. Then, my lord, that if you then, my lord, that has been put before the
Yes.
Yes.
Why affiliation is not being granted?
Lordship, so far as Assam Science and Technology University is concerned, Your Lordship, the pharmacy is, Your Lordship,
Not in your country. It's with the Sankadev.
Sankadev.
Yes, Mr. Gogoi. Who is there for the university?
Why?
Now there is a.
I have forgotten everything when I came this side.
But as per the policy, my lord, all colleges, my lord, who is to impart, my lord, pharmacy education, they are now, they will have to be affiliated under the Himanta Sankadev University of Health. So in the present.
He has applied.
No, he has applied before the ASTU, my lord, Assam Science and Technology University. That was pending. In the meantime, this policy, the policy came in.
Okay.
There is the policy says that, my lord, whoever has already applied and got the affiliation, they will also have to change it. And whoever were.
With that notification of yours, yes.
My lord.
And the NOC has been granted by the government.
No, here there is awaited.
Not the verification was done. They should not fulfill the law.
Not yet, my lord.
Where is that notification? Have you filed an affidavit?
Page 44, your lordship can see. Page 44 of my writ petition.
You are not a part. Yes, respond number 4. Have you filed an affidavit, Mr. Gogoi?
My lord, so far as my lord, the government is here, it is the government will have to, my lord, make this clarification because there is a policy of the government.
No. Have you, he has not even applied before you till today.
No.
Have you applied before the Sankadev?
Not it.
Mr.
Sankadev, I applied earlier, but after that I have applied to the before the my lord.
Mr. Buragoyan, there is a notification of the government which requires all such institutions to apply for affiliation before.
Notification is dated 6/6/2023.
It's in the IA, my lord.
It is in the
Part of the my lord expedition.
Part of the repetition.
In the part, not part of the IA filed by them.
Yes.
Because it is a technical, my lord, subject, so I have applied under Assam Science and Technology University. And this university, this is the act by which the Assam, this university has been, Assam Science and Technology University has been established. Now here, my lord, there is a section 37, it gives the power to give affiliation, and there is nothing in this section that they will have to take this one, my lord, NOC from the government. Moreover, my lord, after that Supreme Court judgment, my lord, for these technical things, my lord, pharmacy administration, that judgment, my lord, that, my lord, Pharmacy Council of India, that your lordship must have read it. Honorable and Dr. S.K. Procedural and others. Here, my lord, specifically says that this is government has nothing to do with pharmacy.
No, we are not. We will come to
It
the
is
government,
paid,
but we
para
just
20,
want to clarify who would be the authority to affiliate you.
my lord.
Who would be the authority to affiliate you?
My lord, here they have said they're from any university. So I have taken the Assam Science and Technology University, and they have they were ready to give. They have said you are already, but only government has not given the NOC, so we refuse to give you. Then ultimately, what happened, my lord? The government, we have this High Court has also interfered and says that you consider this and give the affiliation. And then what happened, my lord? They stop for certain time. Then we have filed a contempt, and that has angered them, and they have made a new notification.
12-6.
Says that we have no power to issue affiliation.
And government
That
has
is,
also-
my lord, that is the Cancellation matter. This is the statutory rule.
Oh, that was
And a
about, I was
deputy
about to ask him about.
Deputy secretary or a joint secretary later cannot negate the provision.
Mr. Ugoi, there is a point that if the act does not prevent Atsu from giving
No,
that
my lord,
affiliation.
here one thing I would like to point out, in fact, that issue of, my lord, maintainability of this IA, where, my lord, they have challenged the, my lord, 6/6/2023 notification as a government policy of the government. Whether, my lord, this independent cause of action can be put to challenge.
No, let's forget. We know that 6/6/2023 is there.
Yes.
Now, there is a statute governing Atsu. There is no bar.
No, sir.
If you have to exclude these subjects from Atsu, you will have to amend that act.
Yes, madam.
You have to amend that act.
The amendment of the Central Act.
No. The act by which this Assam State Technology University has.
Technology University.
Science and Technology University.
My lord.
Now, if that Science and Technology University can affiliate, how can you by way of a notification prevent that? Or is the Shankardev University Act giving any overriding power to the university? Because now earlier Guwahati University, Dibrugarh University used to affiliate.
Yes.
Once Shankardev came in,
Yes.
just check up the act if there is an overriding power with regard to medical. If there is an overriding power, fine.
Fine, my lord, I'm not there.
Just check up.
Yes.
When can you have it?
Lord, will give us some time, so that in the meantime, my lord, the stand of the government will have to place on it, because
NOC, that we will come. If
regarding this
Mr.
particular-
Buragai's first plea that Atsu can affiliate, then we will decide that and then require you to.
No, on that point, because, my lord, this 6/6/2023 has been issued. It is very clear. It's the, my lord, Srimanta Sangoda University will.
We
be
will
the
go into
affiliating
6/6/23 after we see the act of Shankardev. If Shankardev is giving an overriding power to that university insofar as medical education is concerned, finished.
Lordship.
That's the end of the matter.
Another small point, my lord, if I can point out to your lordship. This is the, my lord, Pharmacy Council Act 1948. Here, my lord, there are 3 chapters. Chapter 1, Chapter 2, Chapter 3, Chapter 4, and Chapter 5. In power to make rules, there is section 46, your lordship will see. Here it says that the state government may, by notification in the official gazette, make rules to carry the purposes of chapter 3, 4, and 5. I am in the chapter 2. Chapter 2 has been kept untouched from the purview of government. Here, my lord, chapter 12, section 12. Here I fail, my lord.
I got it.
The approval and courses of studies of.
We will we'll just examine that Shankardev Act.
My lord.
And the Atsu Act. And if Shankardev Act with regard to health, because Guwahati University is also not affiliating now.
Yes.
Dibrugarh is also not affiliating. So what is the provision? Just place it before this court.
My lord, another aspect, my lord. I have been establishing the from 1990, okay, 2019. Now my lord, 4 years has gone. I have to maintain all the,
We on the next date, we will see.
my lord.
On the prayer of Mr. B. Gugoi, list this matters again. When do you want it, Mr. Gugoi? Let it be a firm date so that by the time you can give us the.
February.
Huh?
7th of February.
7th. Okay. Or you can have it on 12th. I'll give you some more time, but get all the instructions. And also why the NOC is not being issued. On 12/2/2024, on which date Mr. B. Gugoi shall place on record the.
Well, there are one or two more petitions relating to.
One is enough.
NOC relating to.
Another
That is
aspect,
nothing.
Not this
Regarding NOC.
same party.
Same party.
That is another aspect, my lord.
This
not
is
for-
affiliation. This is
We
affiliation.
should not mingle all
We'll
these. issues, my lord.
limit it to affiliation only.
Yes, my lord. And
It is only
regarding
for
NOC,
affiliation.
separate petitions are there, my lord.
Better.
Yes.
Why are you angry? It's better. Let there be 2-3 petitions. Can you ask me? Huh? Place on record the what is the name of the act? Shankardev, what is the name?
Remember Sangadev University of Health Science.
No. Act. Name of the act.
That's my lord.
Or the act setting up. The
Assam Science and Technology.
no. The
Assam Pharmacy Council.
no.
Shankardev Act.
It's here. Setting up the Srimanto Shankardev University of Health Science. Okay. Next again on 12th, Ikana.
Item 31.
Obligement.
My lord, in this case, my lord, item 31, my lord, on last occasion, lordship is directed to bring instruction regarding para 14 and 15, my lord. I need 2 days, my lord, accommodation, my lord.
On the prayer of Mr. P.K. Bola, list this matter again on 5/2/2020. Right?
Last time, lordship, already there.
They are getting instructions day in and out. Some matters where we can give some gap, let's give them some gap.
I'll bring.
Item 32 and 33.
Yes.
Wait, please, lordship. But I appear in item number 33, my lord. But I'm challenging the selection and appointment of the private respondent, my lord, who was appointed as headmaster of the school on the ground that he did not have the requisite qualification on the date of selection. Right?
Is there any interim order operating?
Yes, my lord.
Mr. Monto, you are appearing for the
Private respondent, my lord. There, my lord,
Respondent
33, I am appearing for 5 and my lord 32, I am 7.
okay. Readings complete?
My lord.
Huh?
Yes.
Readings complete?
Complete.
We'll fix it on a date.
My lord, any sorted may be given because my lord, my client is at the verge of retirement, my lord. So,
When is he returning?
my lord, this year, my lord, 24. Probably August he is retiring.
On the prayer of the parties, list this matter again on 13/2/2024. An endeavor would be made to dispose of the matter on the next.
13-2, my lord.
13/2.
Final disposal, my lord.
Fine.
My lord.
Obliged, my lord.
Time being item 21.
Yes, Mr. Bhuyan.
Yes, my lord. My lord, page number 96 of the writ petition.
Huh?
Page 96. This is the recruitment.
No, who is this society? EMRS, the library, who is that? In charge principal. That is the inspector of schools. Who is this in charge principal? Yes, Mr. Bhuyan, who is this in charge principal?
My lord, my learned friend has relied on the fresh guideline, my lord. My lord may be pleased to find the fresh guideline. It starts at page, my lord.
Fresh guideline page?
My lord, page starts at page 160. Lord.
Additional affidavit.
Yes, yes, my lord. My lord, affidavit filed by my learned friend, my lord. Page number starts at 159. Guidelines for the Ekalogbo Model Residential School, and this operates from 30th of November 2020, my lord. Now, basing on this guideline, a fresh recruitment is required to be carried out. In what manner, my lord? It has been specified in this guideline. Now, committee, my lord, there are various levels of committees. My lord may be pleased to find that page 163 is the management of schools, my lord. How the school is required to be managed. And page 163, my lord. I am relying, my lord.
Management of schools.
My lord, management of the schools, the various provisions is there. My lord may skip the few part. Now, my lord, this committee part will come at page, my lord, 164. At the state level, my lord, societies is there. Union Territory EMRS societies at the state Union Territory EMRS societies.
District level is at 4.3A.
My lord, 4.3A. Now, whether, my lord, this committee has been constituted or not, that can be only be ensured by my respected senior friend, my lord. Now, if you go by the, my lord, advertisement, it has been seen that, my lord, it has been issued by some principal, my lord, in-charge principal. Whether this committee has been constituted or not, my lord, that is also a vital aspect required to be examined, my lord. And, my lord, in this guideline also one very important point.
Have you dealt with this part in your reply, Mr.?
My lord?
Have you dealt with this part in your reply?
Yes, yes, my lord. In our reply, my lord, in our reply affidavit, my lord, we have relied on, my lord, one important point, my lord. At page 168 of the same, my lord may be pleased to find. Running of schools, my lord, how it is required 9.1 clause, my lord, I am relying, my lord. Why? Because, my lord, it has said, shall provide the detailed standards and norms for the recruitment of the teaching and non-teaching staff and continuation of existing staff, my lord. This guideline says, my lord, those staff who are already there.
Okay.
They will continue, my lord. Now, advertisement has not been issued by an appropriate authority, my lord.
We'll make it all subject to let this today only nothing against you. I'm not even in favor of the government.
Kindly appreciate, my lord, 21 petitioners, 21 families, my lord. If we are out.
You are not getting even a single naya paisa today.
My lord.
You are not getting a penny today.
No, we are getting, my lord.
Who is paying?
No, my lord, we are not getting.
You are not briefed properly. You are not getting. I've gone into that aspect, Mr. Bhuyan.
No.
Heard Mr. A.R. Bhuyan, Learned Counsel for the petition, hear the order.
My lord.
Also heard Mr. R. Learned Counsel appearing for the
Tribal affairs, my lord.
Huh?
Tribal affairs department, my lord.
Tribal
Affairs.
Tribal Affairs Department. Also heard Mr. S.R. Raba, Learned Standing Counsel, Bodoland Territorial Council, appearing for the set authorities. Appearing for the Standing Council, Bodoland Territorial Council. Also, Mr. R. By referring to the affidavit filed by the Tribal Affairs Department, has contended that the said school is now being managed by the delegates of the said department. Mr. Bhor, school is being managed by delegates of your department.
My lord.
So, however, in view of the order dated 11/10/2023, wherein a status quo with regard to any recruitment was till then an order. How in view of the order dated 11/10/2023, wherein a status quo order with regard to recruitment was passed, the authorities are not in a position to carry forward the recruitment process, and as such, the children of the school are being deprived of a proper education deprived of proper education. Full stop. The said prayer is objected to by Mr. A.R. Mia, Learned Counsel for the petition. However, keeping in view the nature of the dispute involved and there being a requirement to first determine the rights of the petitioners in the matter, thus I am of the view that the status quo order be not continued any further and the authorities permitted to proceed with the selection process and appoint teachers. Full stop. It has been stated by Mr. Ardha that the appointment is only as guest lecturer and no permanent appointment is. Full stop. The authorities may now carry forward the such selection process and take it to its logical conclusion. Full stop. However, in the appointment orders issued, it should be categorically mentioned that each and every such appointment is subject to the further orders that would be passed by this court in the matter. Also, the above liberty granted to the petitioners, granted to the authorities to proceed with the recruitment process and make appointments shall not be construed, shall not be to the prejudice of the petitioners and their rights, even if appointments are made in the said school, shall be determined independently in this proceedings.
But we may be allowed to continue also, madam.
That's
Because-
up to them.
No, my lord, because as per their guideline, it says that.
Mr. That guideline would mean a person who is being recruited properly. Here, there is a dispute.
No, my lord, we-
Let us come to that. I have protected your interest. I have protected your interest, Mr. Bhuyan.
My lord.
Okay? I have protected your interest.
Yes, madam.
We will have it, list this matter again on 27/2/2024 for admission hearing, on which date an attempt would be made to dispose of it.
My lord, in between, if they have to imprint anybody, let them, they can file.
That's up to them.
My lord.
When
My-
we
my
say
lord-
final disposal, it's
My
final.
lord, this is still in motion stage, so notice.
No, notice has not been issued yet.
Not yet.
एक काम वो लिखना ऊपर में issue notice returnable 4 weeks. Mr. Hardhop has entered appearance. Hardhop accepts notice on behalf of respondents number
My lord, I'm-
1, 2, 3. Mr. Rabha, S.R. Rabha, S. Rabha, Standing Council, Bodoland Territorial Council, accepts notice on behalf of respondent number 4, 5, 6, 7. 8 also. 8 will be by whom?
No, my lord, that is the governing board of the residential school.
8, 7 and 9. 7, 9, 7, 9. And 11. No, 7, 9.
My lord, actually, these are not correct, because this is not transfer subject, this is a totally central government.
Fine, we forget it. 9. 9. Who will appear for 10 and 11? Committee for recruitment of guest teachers at so and so.
Research
Committee for-
principal will represent, my lord, that the person who has issued the advertisement, my lord.
Inspector,
IC principal come inspector, my lord.
you take steps.
My lord.
A petition, full stop, no formal notice be issued. However, extra copies within 3 days. Petitioner to take steps on for service of notice on respond number 10 and 11 by way of registered post with any. Also, list this matter again on 27/2/2024. उसका आगे में वो जो पहले दिया था उसको लगा.
Lord, may a small prayer, my lord.
Yes.
The process of regularization which they have started, my lord. That they may logically conclude that it will.
I have said that it is without prejudice to any of your rights. Because if I have to say regularize, then I'll have to hold that you are there regularly. That will require some consultation, Mr. Bhuyan. Understand?
I can.
This may cause some trouble to you for a few days, but I think finally we'll have to balance. I'm only concerned with the students, nothing else.
My lord. Obliged, highly obliged.
बाकी नहीं clear करें।
Item 34 for admission.
May I please?
Yes.
In this case, my lord, we have challenged the Assam Social Welfare Recruitment Promotion Service Order 1994. This regard to my lord, this is not in conformity with the RCI.
Yes, Mr. Nath.
Well, the lordship, if lordship is taking up the matter for disposal, my lord, kindly give me 2 days time. Well, I have constructed the file, my lord. I just need to go through the records.
On the prayer of Mr. D. Nath, Senior Government Advocate, Assam, list this matters again on we'll have it on 20th, Tuesday,
Lordship.
22, 2024.
Lordship.
Also, ऊपर में लिखना. Also heard Mr. E. Purkaister, counsel for the petition.
Item 35.
Right, please. My lord, there is a direction from this honorable court to regularize my service way back in the year 2015, subject to verification. Verification done in the year 2016, and I was found to be eligible. And for the last 8 years, they are sitting over the matter, my lord, doing nothing. Lordship will kindly pay the lordship's order dated
Yes.
19/12/20.
May pleases you, Lordship.
Government.
Your Lordship.
Yes, Secretary Education was to file an affidavit. Why?
We have filed our affidavit, your lordship, but there, your lordship, one instance, your lordship, that has not been cleared, your lordship. But
You see the last order of this court, 1912. We just want the reason for the delay.
there is one development, your lordship, positive development is going on pertaining to that, your lordship. We have already made a communication later, your lordship, because your lordship,
Affidavit. Secretary Education shall file an affidavit. You see the order. Because this director had communicated the proposal to you on 8/6/2016.
8 years.
And you're sitting over the matter. Reject it if it is to be rejected with reasons. They will challenge, but how long will they continue waiting for that?
Yes, sir.
What is your instruction?
Your lordship, instruction has not received, your lordship. Already communication letter has sent to the department.
On the next date fixed. On the next date fixed, Ms. Pidas, the Standing Council BTC shall ensure that the affidavit as of the Secretary Education BTC Kokrajhar as required to be filed by the order of this court dated 19/12/2023 shall be brought on record. Next date, bring it on record. I'm giving you some time, but we want this on 20, on 19/2/2020. 2024. We have given you enough time, thus, so that just comply with that.
Item 36.
Thank you, lordship. My lord, this lady, my lord, struggling. This lady working, my lord, in the school since 1995, my lord. And ultimately, she was found eligible for provincialization. But as her name was not found in the dice code for the year, my lord, 2015, 16, 17, my lord, she was not given benefit of provincialization. As per, my lord, settled principle of law, my lord, so far, my lord, provincialization of teachers.
I think in one of your cases, I passed an order. Oh,
So, my lord, this is the case, my lord. Her case
Yes.
may be
Your lordship, we have
considered, my
filed our affidavit, your lordship. I would like to take you in paragraph 4, your lordship, page 48, paragraph 4. That as regards to the statements made in paragraph 4, the answering deponent beg to state that the UDICE report of Digor Sircona High School bearing dice code number so and so is enclosed, and there is no provision in the UDICE for updation, modification, and alteration
so
of
you
the
mean
data.
to say that her name is
Her
not
name is
there?
not there in the data, your lordship. which has already submitted and uploaded for the previous year.
What happened for 2009-10 onwards? 9-10, your name is there.
My lord, my date 2014, I have annexed, my lord, last one. Lordship, kindly have a look, page 46, my lord.
Nine.
Till 2013, 14, my lord, she is there, my lord.
13?
13, 14, my lord.
page.
12, 46, my lord. Last
39. 12 and 13. 13 is 13 to 14. Her name is not there, your lordship. Then 14 to 15.
page 46, my lord.
Her name is not
This
there.
one? Mr. Bhuyan, this one?
Yes, my lord, page 46.
Annexed to this one.
Where is her name? Ajanta Sharma, 11. Okay, what is this? This has got nothing, starting, no ending. But the data at page 58. This is of 2013-14.
Yes, sir. And my lord, the observation of the concerned authority, page 44, my lord.
13-14, your name is not there.
Not there.
You have received the copy of the affidavit. Vipasi,
Again, sir.
Lordship, kindly have a look, page 44.
Mr. Bhuyan, have you received a copy of this affidavit?
My lord, this affidavit perhaps I have not received, my
Ms. Pidas, you have not
lordship.
received? Yes, for Mr.
I
M.
beg to
Burmia,
submit, my lord.
advocate.
And
Somebody
as
has-
per this judgment, my lord, for high school teacher, my lord, my lord, considered all the, my lord, relevant law, my lord, not necessary, my lord.
Okay, they have filed an affidavit. You examine. It has been received. Somebody has received on your behalf. 9-10-2023. Somebody has received on your
Yes.
behalf. On the prayer of Mr. A.M. Burmia, list this matter. Again on 12-2-2024.
12 to
12. Will consider.
deep your blocks.
Supplementary list item 49 and 50.
Last occasion, your lordship directed me to produce instruction, my lord. I have received a instruction, my lord. Today morning, I have received. Eight.
That
My lord. 49 cancel, my lord. Order.
what is this 27-10-2023?
That was, my lord, order passed by this honorable court, interim order, my lord.
2710, after compliance of the interim order of this honorable court,
You have been.
they have here.
Okay. You are enjoying.
Yes.
They have cancelled. Anything more left in this petition?
Well, regarding the proposal for inquiry, other part with regard to the private respondent in the that debate may be given.
That we will not go into.
They made absolute.
That is not even your prayer. Your prayer is only this. A disposal. Heard Mr. D. Purkhaista for the petitioner. Don't write that. All right.
That was prayer in the earlier petition,
Ah.
2210, not in this.
Not in this. That's why I was surprised. Standing counsel, elementary.
My lord.
Disposal.
Obligement.
Then 2210, what we do?
That may be also disposed of, my lord.
That is already disposed of. No.
Not
That can be disposed of in this line. What is the challenge there?
there was impugn, my lord.
Lipika Sinha.
Yes,
That was already cancelled.
yes.
Hmm?
It's cancelled. Additional prayer was there that to cause an inquiry with regard to this and to bring the logical conclusion. That was there. Nothing else.
Where is that cancellation of Lipika Sinha in your this petition? I think it is there.
It is here. Here impugn order is the cancellation one. 51.
Okay. 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 We'll pass orders. Retired dispute.
Obliged. Obliged. But item number 22 is a motion item. My learned friend was asked to item number 22. That was a motion item, my lord. There was time being. Learned friend.
What happened? Yes, Mr. Any
My lord,
insight in 22?
Mr. Asuti is supposed to print out purchase on Lakes at court number 17.
Okay, we'll wait for someone.
For orders, item 38.
Your lordship, may Peru the last order dated 8/1/2024, my lord.
Yes.
My instructions of 10/1, my lord.
Not an attack copy আছে এইটো ঘূৰাই ল'ব এইটো মই কপিটো দি দিব লাগিব এইবিলাক কৈছো তাহাঁত তোমাৰ সংকট ঠিক আছে
Have you received that amount, Mr. Bora?
Yes, my lord.
Have you received the area salary, that amount? No. Deducted amount? No.
No, my lord.
What is this area salary, Mr.? You had deducted overdrawn according to. You have to refund that only.
Is that
Where is that area salary concept coming?
No, that area salary concept is the calculation that she had given to us, that this is what more I am supposed to get. All that has been taken into account.
Fine, but we are not concerned with what she has given. We are concerned with this
that
order.
entire proposal.
13,57,441.
My lordship will find 1 or 2 pages. I have only one copy, 1 or 2 pages before that. The amount deducted, the amount paid, everything has been calculated out, my lord, by the inspector of schools. If lordship has the contempt petition, their lordship will find.
I am only concerned with that 13 lakhs.
Yes, the 13 lakhs, how it is not done is also there by the inspector. of
You
schools.
go through it, we will have it. Mr. R.
Out of that,
Mujumdar,
some
in
4
terms
lakhs
of
is
the
to be given.
orders passed by this court on 8/1/2024 has received, has submitted that he has received the instructions and praised for 2 days time to place the same before this court. List this matter again on 2/2/2024, on which date Mr. Mujumdar shall place instructions as to why the amount withheld from the pension benefits of the petitioner was not refunded till date.
That refunded part is
That
already.
you tell me on that day. You see and tell me. So this is all jumbled up.
Financial matter.
But not
Beyond-
financial matters.
Their calculations beyond me.
You go through it.
I'll do.
Obliged, my lord.
Item 40.
May I please your lordship? Lordship, as per instruction of my senior RC Sarkia, the order was already complied. So I want to withdraw this petition.
Mr.
P. Sharma.
P. Sharma, learned counsel appearing for the petition on instructions submit that the directions passed by this court wide order dated 2012-2019 in WPC number 9409/2019 has since been complied with. So, in view of the said submission, this contempt petition stands closed. That's it.
No, here, my lord, one of the relative of B. Kaushik is passed away today, my lord, so he is not.
It is submitted that Mr. B. Kaushik is in bereavement. Also, B. Kaushik, learned counsel for the respondent is in bereavement. Accordingly, list this matter again on 9/2/2022.
Obliged.
Item 42.
Hearing kita bisa probably.
Miller, I am on behalf of the petitioners of next case 2123. It is filed for restoration of contempt case civil number 139 of 2018.
Now, ma'am, now there is an order
Yes, my lord.
that you have to address this court on the issue. Are you ready? With regard to the formulation in the order dated 3/5/23. Have you got the order dated 3/5/23?
Yes, my lord.
And then 12/5/23, right?
Yes, my lord. Because it is filed for restoration of the initial proceeding, which is dismissed for default. That it is not initiation of proceeding as per the section 20 of the Contempt Proceeding Act. So, my lord, it is pending since 2018. And
What is the order?
Yes, my lord.
What is the order violated?
Initiation of the proceeding of contempt cases started on 2018. my lord.
Because what has happened here with the dismissal of the petition, the order also notice issue was order issuing notice was recalled.
Also recalled.
So 1 year is gone now. Now whether we can.
So it may be restored and I may be allowed to issue a notice of restoration to the respondent my lord, by saving the initiation of proceeding filed order as a 4/4/18.
List this matter again on 1/2/2024. We'll think over it, Mr. Pradhan. We'll think over it. 1/2/2024 for further consideration.
Okay.
We'll think it on one first.
Item 43.
May it please, my lord. But in this matter, we had applied for, against certain vacancies, we had applied for appointment as postgraduate teachers in the district of Dhubri, my lord. After our appointment was notified, when they notified the schools in which we were appointed, we found that the schools are in South Salmara district, my lord. But South Salmara district was never a district where vacancies had been notified, my lord. And
yes, what is your stand?
I have to take instruction regarding.
All right. Notices were issued on 25/8. Then 15/12, I issued. Only a small thing, what is happening? That much only. We don't file a detailed affidavit, just get that instruction. Okay. On the prayer of Mr. U. Sharma, list this matter again on 5/1/2022, on which date he shall invariably place on record the stand of the respondents with regard to the claim made by the petitioners in the present proceedings. 5/2.
Item 44.
Yes, Mr. Majumdar, what happened?
Lordship, my learned friend appears.
Yes.
Respondent number 2, 3, and 4.
Lordship, my learned friend is perhaps not aware of the fact that in these admission matters, several other cases were also pending before the Honorable Justice A.M. Bujurubha before his retirement. And in those matters, certain directions have been issued Lordship, what has happened is in the district of Karbi Anglong, this racket of false certificates of OBCs has been going on for quite some time. And to tackle that situation, the government of Assam had come up with a notification saying that the OBC certificate has to be re-verified by the authorities concerned. I'll place that document for the Lordships. Lordships, insofar as the students are concerned, what is happening is that they are declaring themselves to be OBCs. They are getting selected in the merit list. And when the actual verification of documents comes in, they don't produce the relevant documents. As a consequence, they block one other OBC candidate, from a genuine candidate, from getting the seat, your Lordships. Now, if I may just place the notification, what has happened is, in the earlier round of cases, the question which arose before the Honorable Court was with regard to the titles of Singhs and Chauhans and how they can become, how they are a part of Koiri and Nunia community. As has been claimed, they are claiming to be a part of the Koiri community of under this thing. So Lordships will find that there's a judgment, which is not a judgment, it is an order which has been passed by the Honorable Court, wherein the candidates concerned in those particular cases have been directed to appear before the state level scrutiny committee, Lordships.
And he has not produced his father's certificate.
He has produced his father's, not his own.
Uncle's.
Yes. And his uncle, your Lordship. Yes.
I had asked him this question.
Lordship.
Now, and in as per our admission guidelines, your Lordships, it is very clear. We have very categorically stated.
Do one thing.
Yes, your Lordships.
In addition, I can accept your oral submission. There is no problem, but he will be taken by surprise.
Correct.
So why don't you file a short?
I will. I just because
a short affidavit.
Lordships, may I just place on record this? I deprecate the practice of not serving copies on standing counsel, your Lordships. I'm a standing counsel of NVS. My learned friend is aware of that, and yet without serving copies on us, they try and get these matters listed. And unfortunate as it is, we can't.
We had not proceeded in the matter. Seeing the
I'm
issue,
deeply grateful to your
we had
Lordship for
only
that.
issued a notice.
Lordships.
Although Mr. Majumdar was very vehement on that day. Anyway, I'm keeping this on record.
Lordships.
May I say, may I?
No, we'll not give her much time. We'll give her only a week's time. She'll file an affidavit. 10 days time.
10 days.
Lordship, in the meantime, Lordship,
No, let's get to the root of this. Let's get to the root of this, Mr. Majumdar. List this matter again on 5/2/2024.
Lordships could have perhaps be 6 to and 5 to have
Seven,
something.
7 to
Lordships.
2022. 2024.
Lordships.
Ms. R. Suratia.
R.S. Chaudhary.
R.S. Chaudhary. Shall file an affidavit on behalf of the Navodaya Vidyalaya Samiti on or before.
Numbers 2 to 5.
Respond numbers 2 to 5 on or before the next date fixed.
Lordships.
If possible, get it on record. So that
Absolutely, Lordship.
Lordship,
Before that.
may I pray, Lordship, the seat, that time of the admission, Lordship, apart from that,
no, if we find that,
if I am, Lordship, out,
if I find matter in your favor, why we can always direct them.
You, Lordships will, if your Lordships direct, we're absolutely ready to do it.
They're ready to do it. They have to do it.
because then they will say, Lordship, with you all fairness.
School, it's not medical education. It's school.
It's cool, your Lordship. Deeply obliged, Lordships.
It may come on the
7th of
7 to.
Supplementary for orders, item 51.
Lordship, regarding that matter, correction of name. Petitioner counsel is absent today also.
What to do?
He is not interested, I think so. The council.
None has appeared on call. Full stop. On the earlier on that also, none had appeared when the matter was called up. Full stop. List this matter again on 5/2/2024. In the event there is no representation on behalf of the petitioners, orders as may be required shall be passed in the matter. Mr. M.S. R. Bora for the Central Board of CBSE. Standing Council, CBSE. R. Bora, Standing Council, CBSE. Yeah.
Time being item 10.
Have you got a reply?
Yes, my Lord.
Yes.
My Lord, if we may turn to page 36.
I'm in 36.
There are two parts to that finding towards the last page, my lord, if I may be permitted to read it. First is, for all the aforesaid reasons, the matter is remanded back to the disciplinary authority to consider as to whether the charge of unauthorized absence from duty could entail the penalty from removal of service. That is number one. Number two is, after deciding on that, the authorities, if they take the decision to reinstate the petitioner in service with any one of the lesser penalties, same will not entitle the petitioner back wages. Now, my lord, when they decide to reinstate me with any one of the lesser penalties, that has to be in consonance with the Assam Services discipline and appeal rules, where discipline, the section discipline is, my lord has it,
You go ahead.
is in part 4.
That's the answer I wanted.
And my lord, to that effect, I also have a judgment of the Supreme Court, if I may just.
Your contention is that this court had remanded back the matter for imposition of a penalty.
Yes.
And you have issued a,
Appointment.
that's the answer.
My lord, this judgment,
In the morning, you had not come out with this.
I was confused, my lord. I was rather scared.
Right? You should not be.
My lord, at page,
Para?
page 344, para 21 and 22. May I read it, my lord?
No need.
Para 21 and 22 discusses the idea
I
of,
know.
especially para 22.
Now that you have answered my query, rest will follow.
But my lord, there is one more interesting point. This judgment also discusses the detailing of back wages, wherein here, my lord, there is no fault.
No. That back wages you will not get because this order has attained finality.
No problem.
Yes.
Worship, I'm just a formal party. I'm appearing for the Corporation Department.
Who is the main party then?
The State is there and the Fishery Department, Your Lordship.
They are not here? It's a top of the list matter.
Yes, it's a top of the list.
But Ms. Chaudhary, Learned Counsel for the petitioner, also heard Mr.
G. Bodley.
G. Bodley for the respondent number
1 and 3.
1 and 3. None appears for the respondents.
2 is the Fishery, Your Lordship. That's one number 2.
For the respondent number 2.
4 and 5, Your Lordship, the Fishery Department.
4 and 5. Hearing concluded. No, dispose of. Orders follow.
Gotcha.
But you will get it only next week. Dispose of.
My lord, one small request, my lord, back wages may not be mentioned by this order, my lord.
No, back wages is already mentioned by the earlier
By
code.
the earlier code.
So how can I go beyond that code? Not because of the name, because of the order.
Deeply obliged, my lord.
Lordship, one small interference, Your Lordship, if your Lordship permits me, with regard to item 44, Your Lordship, this was the instruction that I had from the district commissioner.
Okay, we'll keep it in 5.
Yes,
We'll not take anybody by surprise. Give him a copy if you have.
Yes,
if you
yes,
can.
yes.
Give them a copy. Get a file out my 21.
Obliged, Your Lordship.
Timing item 8 and 9.
My lord, 8 and 9 are connected matters. This is from my lord Larry Wallam, Northeastern Regional Institute of Water and Land Management.
Lordship.
Now, so far as this item number.
Yes.
Deputy RGI is appearing in this case, Lordship. He is in court number 2. It may be taken up after some time, Lordship.
Sometime it's already 4.
Lordship.
But I have got a prayer now. I will not object to the request of my learned friend, but I will draw your lordship's attention to 2 orders of this honorable court by which the records, particularly the
28/2/2014 and earlier order.
And 10/4/2018.
I've seen that.
Because my lord, this is important in view of the fact that originally this was pursuant to a matter of open selection. And thereafter I was appointed on contractual basis, then on different rates, contractual, daily wage, and whatnot, my lord. Therefore, the initial advertisement will be very important.
And I made a prayer and this honorable court directed them to produce the advertisement that they are not producing.
Okay. Because we find that there were others also who were recruited like you,
Yes, my,
but they have been then made temporary, then made regularized.
yes.
But you have not been made it because
And
they say
Hazarika,
you
I
were
have-
initially for a very short time,
Yes.
then you were in some projects.
Yes. And eventually, my love, this petitioner, she has attained the age of superannuation
Oh, she is retired.
and she is a cancer patient.
He retired on intent.
On the prayer of Miss RDV, let's list this case again on. As RDV CGSC list this case again on. We are not giving you a long date, short date. 6 would be fine with you, Mr.
Right.
Chod, on 6/2/2024. On the next day, the respondents are required to produce before this court the initial advertisement leading by produced with this court the advertisement under which the petitioner was recruited in the respondent organization along with the other connected records relevant to the issues arising in the present proceedings. The records in original shall be produced on the next date fixed by Ms. RMSRDV. Get hold of the records. Cancer patient will have to finish it up.
Obviously.
Highly obliged. बाकी सब फेंक नहीं गई मानो मत इसीलिए मत तेरे 12 टमाटर
Item 12.
Yes, Mr. Chong.
My lord, yes. My lord, punishment, my lord, by way of my lord. For feature of my lord gratuity amount. To the extent
Mr.
of
Chauhan, would you mind? Mr. Chauhan,
my lord.
would you mind if I take a clarification from Mr. Roy?
Yes, sir.
Mr. Roy,
No.
one clarification. That 4 lakhs penalty recovery which you have been ordered, it's in connection with charge number 3, right? Just check up.
Because it is the only charge which is, my lord, this is the basis, my lord. which
Only
is
on,
for the- yes, it has
can
to
I
be.
proceed on that behalf, with that
Because
basis?
charge number 1 is not proved.
Two,
Charge
that-
2 partially proved.
that
Charge
this
number
part is
3.
not proved.
Charge
So
number
3
That's right.
is the only charge wherein you have made the recovery.
Recovery of the losses, my lord.
Losses, 4 lakhs partial.
Lordship.
So we
Not
proceed.
all.
Huh?
Not all. The loss
4
is-
lakhs. 4 lakhs.
And this was, I think, my lord, payment has been made to him, the remaining amount.
The remaining amount has been paid. In your affidavit, you have said.
Court order, my lord, they really.
Okay.
The
But
remaining
we
amount has been
proceed,
paid.
Mr. Roy, we proceed that it's with regard to article number 3.
Yes, yes, Lordship.
Yes, proceed now.
My lord, article, in fact, my lord, the presenting officer not praised before the inquiry officer because, my lord, the main reason being, my lord, the document, my lord, not supplied to my lord, this, the petitioners.
Mm.
My lord, my lord, I'm showing, my lord, the series of order passed by my lord inquiry officer to furnish my lord record the document, but not furnish.
You can come to the inquiry report with regard to the findings there. I
Yes.
think the other things will be get covered there.
Yes, sir, yes. Sir. My lord, it start page 111.
Yes.
Charge number 3, my lord, it start, my lord. Page, my lord, 148.
Hmm.
Yes,
Proceed.
my lord. My lord, first of all, my lord, I am drawing with kind attention, my lord, page 150. It is the conclusion of the, my lord, inquiry officer. 9.3. As the PO has not praised the charges in article 3, the CO, while referring to the CBI report, in case filed on 24/3/2010, has pleaded for being discharged from this case. And as such, CBI inspector could not attend inquiry proceeding in spite of the notice issued to him, nor did the CBI make available the copy of document to PO or IO. The matter may be decided by the FCI management, who might have received the CBI report by now. So, my lord, practically, my lord, there was no inquiry at all, my lord, regarding the charge number 3. Because, my lord, inquiry officer, my lord, repeatedly, my lord, pass order, my lord, directed the presenting officer to furnish the document. Despite of that, my lord, documents were not furnished. And so far, my lord, the CBI case, my lord, concerned, my lord, in both the cases, my lord, petitioner acquitted, my lord. I have the judgment with me.
You have, I think, produced. It's with me. The judgments were in the record. 2 judgments.
Yes.
These 2.
Yes, my lord. Follow me now, my lord.
I don't know who has produced, but it was in the record.
Yes. And my lord, my first, my lord, contention is there, my lord.
Special case 5A and special case 5.
Yes, my lord. That apart, my lord, first of all, my lord, while the
Mr. Chavan, you have to produce it, otherwise who is going to produce this?
Whereas, my lord, I have forgotten one minute, my lord. My lord, is the, first of all, my lord, this, my lord, a person retired. He went, my lord, and handing over charge and everything.
That is
my
again disputed, because on 39, when the there is a report, you have not even condoned, you have not disputed that. 39, they say there was a committee of officers who went to your house, you refused.
From the letters, my lord, from the letters, my lord. My lord,
You say you received it on 6/10.
yes, my lord.
You contest, Mr. Chavan, you contest on the merits. Tell me, what is the error?
After the, my lord, retirement, on 6th, my lord,
You received it, but they have brought on record an committee, officers committee. Let's give it to them. You proceed.
Committee, my lord, what the committee or my lord disciplinary says that only statement, no document, nothing else.
Okay.
So that that's her, my lord, prior to my retirement.
Okay.
And my lord, their contents of my lord, they pasted the, my lord, this copy of charge sheet. My lord, in there by regulation, regulation not close. This is not permissible, my lord, as per their regulation. Regulation 75, my lord, at page 65. Service of order, notices, etc. Page 65.
Okay.
Every order, notice, and other process made or issued under this regulation shall, as far as possible, be delivered or tendered to the employee concerned in person. 2. Where such order, notice, or other process cannot be served personally at the above, the notices shall be served on such employee by a registered post acknowledgement due at the address of the employee available with the corporation at the office where the employee was last working. And if he is on leave, as per his leave application, particularly if any. If the notice sent by the registered post in return answer, it would be published in the local regional language newspaper and all India newspaper is appropriate upon the such application. It shall be deemed to have been personally served. So, my lord, according on their own, my lord, procedure, they have not adopted.
Got it. Noted. Next.
So far, my lord, charge number 2. Charge number 2, my lord, in 2005, while I was, my lord, deputy manager, my lord, then, my lord, I was, my lord, in the team. In the team, my lord, visited the particular place, my lord, where, my lord, the FCI go down to be, my lord, constructed. Thereafter, my lord, after 5 years, in 2010, while I was on promotion, my lord, as deputy manager, my lord, I, my lord, requested the authority and recommended that that I saw that there is water to the level of the road and in surrounding.
You
So
wanted to
it
increase
was
it,
some-
33.
Yes. Then after, then my lord, it was my lord, went through 5 other officers, my lord, my seniors. First, my lord, this local my lord manager, thereafter from Guwahati office, my lord, thereafter, my lord, the White office. And there, and also, my lord, this head of the department, my lord, civil engineering, my lord, NIT, my lord, also approved. And I selectively alone, my lord, for partial liability, it is a discrimination, my lord. Violation of Article 14, my lord. So, my lord, charge number 2, my lord, they adopted the principle of discrimination. I have, my lord, mentioned the name in para 12 of my lord affidavit in reply. Para 12 of my lord in my reply. The persons, my lord, recommended, my lord, I may be allowed to read, my lord.
Please read.
Affidavit in reply, para 12.
Yes. Para?
Para
12.
12, my lord, I am, my lord, reading from middle, my lord, page 6 of affidavit in reply. Initially, such proposal regarding my lord, charge number 2. Initially, such proposal was made by S.K. Das, the then manager, CE Silchar, and recommended by J. Ramanna, the then AGM CE Silchar. But based on such, this depending categorically capacity of AGM CE RO Guwahati subsequently made the proposal for raising height of the plinth area by 33 meter. Said proposal was referred by A.K. Roy, the then executive director, he is higher than me, my lord, and any Guwahati to an expert from NIT Silchar, Dr. D.N. Bhattacharya, head of the department, who opined in the positive manner, and thereafter the same was forwarded to FCI headquarters, New Delhi, where A.K. Pathak, then AGM Engineering, also recommended, and finally approved by Dr. Amar Singh, the engineer, the executive director, engineering, FCI headquarters, New Delhi.
Mr. Chavan, we have read it. It's fine. We have noted it.
That fellow, my lord, this Dr. my lord, Amar Singh, my lord, subsequently, my lord, promoted to chairman, and he had my disposed my appeal, my lord.
I got it.
He disposed my appeal by way of rejecting my lord. So, my lord, he should not be taken this appeal. So, regarding charge number 2, my lord. Charge number 3, my lord, if you lordship see the order of the inquiry officers, my lord. My lord, page 175.
The inquiry officer's report, you
Inquiry
can,
is daily order, my lord.
you can just ignore that.
Yes.
Because it says no, because PO did not press that charge.
Occasion, my lord.
You can
direction
start
was
from
there.
the disagreement note of the disciplinary authority.
Yes. 12 occasion, my lord, this he directed, my lord, this
He has categorically said that.
and my lord, charge, my lord, not press. That means, my lord, there was no inquiry at all regarding charge number 3. And my lord, this charge number 3, my lord, finding on base of the, my lord, CBI report. And those documents never mind of furnished to me, my lord. And CBI officer or anybody not, my lord, turn up to deposit for this, my lord, inquiry officer.
Page 150 is that PO has not pressed. So that is the end of the matter for that. Then you can deal if you want with the disagreement.
That I have gone through, my lord. is mainly based on my lord, this report of the CBI.
It deals basically with that.
Yes.
It agrees with the conclusions of Article 1 and 2. And 3, it brings its own reason.
Yes, my lord.
Fine.
So, my lord, this disagreement, my lord, because my lord, this my lord,
When was your date of retirement?
Yes, my lord, on 30th September 2010, my lord. September 2010, my lord. My lord, it's page 30 onward, my lord. Page
One clarification, Mr.
Page 30
Come on.
onward.
You had retired on 39/2010.
Yes, yes.
Penalty
No,
was imposed on 24/9.
His superannuation date is 39, but I think he's appointed before that. Oh, yes, 39.
30.
And your penalty was imposed on 24/9/2011, nearly a year after. This period, what they were paying you?
Nothing, my
Nothing.
nothing.
Okay.
Page 34, kindly see, my lord. They delivered to me, my lord, on 6/10,
Fine, I
after
got
my retirement.
That much we will take.
Yes. And my old card, my lord, I submitted, my lord, deposited, and they received, my lord, proximity card, medical card, etc. My.
Okay.
So
Anything more, Mr. Chauhan? Any judgments?
my lord, my last submission, my lord, that my lord, I did not get any chance, my lord, to revert, my lord, this child number 3, because I was not supplied, my lord, document. Number of document, I in my reply, my lord, given they had the list of my lord document, and my lord, they asked my lord several times.
They could not produce that.
Yes.
Okay.
My lord, based on my lord CBI report, but the CBI court, my lord, acquitted me. They are same charge.
You are relying on the decisions of the trial court. These two decisions you are relying on.
My lord.
Okay.
This is my submission, my lord.
Okay.
My lord, lordship, my lord, about many of the judgment, my lord, on this point, I have 2-3 judgments. But
Please.
lordship, my lord.
You build up your case.
Yes, my.
You can just mark the paragraphs also there.
My lord.
Can you give me the citations?
Yes, yes, my lord. Number 1 is my lord 2007 6 SEC 694
6/9.
694.
Pay party.
Party, my lord, UCO Bank and other versus Rajinder Lal Upar.
Rajinder Lal Kupar's case.
Yes, my lord.
To the proposition that the proceeding having initiated after the retirement, dismissal, this punishment could not have been
Yes, my
imposed.
lord. Paragraph 23.
Okay.
Next one, my lord. 2008 5 SEC. Page 257. Oh, my
Party.
lord, sorry, my lord, the same judgment. The same judgment.
Anyway, just give me these citations. That's all. Para 2008 5 SCC.
My lord,
Okay, you settle it.
it is the same judgment, Rajendra Lal.
You settle it. We'll hear Mr. Roy. You settle it. You said you get your things in order. This is your submission.
My lord.
Yes, Mr. Roy.
My lord, basically, it's on charge number 3, you know. I'll confine on that. The lordship has seen the influence order. Influence order deals with everything, my lord. And as against the disagreement note, my lord, he has sent the reply. Lordship has seen the reply perhaps, page 76. He simply said, my duty is to check only 10% and all. My lord, he being the overall in charge of the engineering department, he is AGM, CE with civil engineering. He is in charge, he is the authority, my lord, to sign, because all are below him. It should not be like that, that everything he has sent to him, he will, without application of mind, approve it. He has approved everything. He being the in charge ought to have been careful. So therefore, the reply to the disagreement note is lordship has by the impugn order has dealt with by the disciplinary authority adequately, and the authority has passed a reasoned order. The lordship has seen that. As regard, he said that he was not furnished the CBI report and all. The disciplinary authority has dealt with it. They said CBI report has been served on the CEO so and so, and so as to give him reasonable opportunity, reply the allegations so and so. But AC thus declined to receive this the reply, lordship at page 164. But in his appeal also, he did not say that he has been so much prejudiced for that. The appellate order I have annexed, my lord. In the appellate order, in the last 2 lines, the appellate authority has given, if you so agree with the appellate order, you can also file a that remedy also was available to him within a period of time, 30 days or 45 days. He did not avail that remedy also. He approached straight away. And,
he had more confidence on us.
my lord.
He had more confidence on us.
Everybody has, my lord. In fact, we used to rush to this court, my lord. Your lordship is aware of that. So, my lord, I don't think, my lord, there is any perversity in the order. He has not also pointed out any procedural infirmity, my lord, infirmity in the proceedings. So far as the the power of the authority to during the pendency of criminal case, that is, lordship is aware. Should I not
give me? I am a new learner here. Nagaraj.
Lordship is aware, but this at least in this court before lordship. So, my lord, there is no infirmity. My submission is, my lord, there is no infirmity in the order, and the petitioner has not also been able to make out any case, my lord, of perversity or procedural infirmity and all.
Ramlal Bhaskar. Now, this is the law holding the field. Ramlal Bhaskar.
That's right.
Rajinder Cooper was said to be in the facts of that case.
That's right. In fact, I brought it in at the time of my lord admission.
Okay. Mr. Just show me the power of your, under your regulation or your somewhere, or maybe under law.
During the, after the retirement and all.
No. That I'm not even going into.
That 63, that's power.
I'm accepting your 39. I'm accepting that. My case is, my query to you is, the inquiry, in the inquiry, there was nothing done with charge number 3. Why did the disciplinary authority not remand back the matter for a further inquiry on that?
Well, is it necessary?
Yes.
It is necessary because
necessary.
What is
because
necessary?
these documents that he has taken on account were never proved in.
I understand. So
how can we give
what is necessary is, my lord, to give him an opportunity. What is necessary is that he shouldn't be prejudiced, because that is why a disagreement note has been given. He didn't ask for a fresh inquiry, my lord.
Where is the provision with regard to disagreement note in your regulations?
That's 58.
Because Mr. Roy,
Lordship,
even if this is, everything is correct, if this we allow, this is, would relate to harassment of the petitioners,
my lord,
or the employees. If we give you this power,
my lord, Lordship, when
I would have understood if these materials are there in the inquiry.
it is there, that's
It's
why, my
not
lord.
there. It's not proved.
No, no,
Article of charge number 3 was not gone in.
it was left to the authority.
No, cannot be. It was not pressed.
Inquiry officer has said that.
Then you become the inquiry officer again. The disciplinary authority becomes the
my lord,
inquiry. Where is the author?
My lord, in a disciplinary proceedings, inquiry, the disciplinary authority can himself also make an inquiry.
Do it. Then even
They
the
make
inquiry
it-
report is not given to be given.
No, that's right, my lord. I'll just take it, Lordship, to the disagreement. It should be there, my lord.
Because disagreement is always on the materials which is coming on record in the inquiry. These materials had never come up on record.
My lord, regulation 59.
50?
59, page 51. Page 59 at page 51. 59.2.
Yes.
The disciplinary
Come
authority.
to 2. 59.2. Thank you. This is what I was looking for. Now clarify on this.
The disciplinary authority shall, if he disagrees with the findings of the inquiry authority on any article of charges, record its reasons. Recorded his reasons for such disagreement and record his own findings. He has given his finding here on the chart if the evidence record is sufficient for the purpose. If the
Now,
disciplinary authority.
Mr. Roy, the requirement is evidence.
Evidence is, to him it is sufficient.
No, evidence. How can you deem this
My lord,
document to be an evidence?
My lord, why the report of the CBI cannot form part of evidence? My lord?
No, it has not never been produced in the. You are an expert in civil.
No, my lord.
No. One of the exhibits, prior to becoming an exhibit, it is just a document. Then it is
Lord,
it is exhibited.
It is not
No, I'm not on that. I'm not on that. It is exhibited. It converts itself to an exhibit, proved, content proved, author examined. It becomes evidence. Now, any document lying somewhere, can it become a evidence in an inquiry without it being even adduced in the inquiry? That's my query.
What is required is material.
No, material adduced in the inquiry.
It's true. It is evidence. It is not that it is not true.
Okay.
My lord, if he would have said, my lord, that these are false, he has not said so. He
need not.
He did not dispute that.
He need not even say anything, Mr.
No, he did
Roy.
not.
He can just sit tight. It's for you
My lord,
to establish.
my lord, it would have been if he refused to accept it, what the authority will do with it? What the authority will do? Can the authority not accept it as a part of it?
No,
If he refused,
you should have gone
what
for.
to do?
You had an opportunity for further hearing. Remanded back the matter on that point. Ask the inquiry officer to hear. Otherwise, what is the necessity of that power?
Bring material to the appellate authority that this document you have relied on, authority has relied on, is perverse on the face of it. Bring the material before your lordship that this document CBI report is perverse before. Then only lordship will remand it matter back to the authority. Otherwise, my lord.
I would have, Mr. With this nature of allegations, if it was shown to me that.
And your lordship will consider, will take into consideration the charges, the allegation.
Allegation.
No work done. He certified the work to be done.
Mr. Roy, can you just come to page 154?
154 of the
writ petition.
I understand. In fact, it also struck my mind. It is not that.
I know. Mr. Roy can't go beyond what he has in his hands. In the enthusiasm to get to an end, the respondents normally do this mistake.
154 is.
These are the documents you are saying. Now.
Yes, 154.
Page 154, you will find.
Yes.
Serial number 1, work order. Okay?
Yes, work order.
Now, just about that.
The charge relates to two.
No, just about that. CBI report
article
in R5A20 GWH conclusively proves execution of the work on paper only, right?
Which one, my lord?
154. Down below, bold 1 is written.
Below CBI report. CBI report number 5. Lordship is looking into that.
5A,
Conclusively proves. This is proves.
Okay, that is the document you are taking into account.
Yeah.
You come to the list of documents.
List of documents of the
show cause at page 45. Can you trace that document somewhere?
No, my lord, this perhaps I have also checked that.
So,
my lord,
even if it is not a part of a list of documents, listed documents, how can you call it to be an evidence?
My lord, this is a virtually this is a show cause.
Yes, and the
Virtually,
documents.
this is show cause.
Documents. Read page 45 opening lines.
Lordship, while looking
just 45 opening line. Then you
no,
submit.
my submission before Lordship is disciplinary proceedings. Lordship is aware. It is not like
need not be.
But
so it cannot be in error also.
When your Lordship will look into my submission is when your Lordship look into the disagreement show cause. Your Lordship will forget the original show cause because this is virtually a new show cause. We disagree with the findings and with the disagreement note given given details of the documents relied on. He submitted a reply against that. Lordship cannot say perhaps that he has been denied the opportunity of hearing.
No, never. You had given him full opportunity.
Yes. So,
but I am on the question.
Because after
at this stage, you had given him.
At this stage, when the authority found that the inquiry report is not acceptable to authority can and has given the details of and he has submitted it. Lordship will look into his reply.
Mr. Roy,
Lordship.
We'll continue on Thursday.
Lordship.
You examine it.
Lordship, I'll do that. In fact, I was expecting this query from your Lord.
That is again bad. A judge becoming predictable. Heard Mr. John and also Mr. P.K. Roy, Learned Senior Counsel, appearing for the FCI authorities. So, heard in part, list again on 25.
Can it be a week after that? Some part had been in court number 1, 2.
5 minutes, 10 minutes on 25. That's why I want to reserve it on that day. Whenever it's convenient to you, just clarify on this point. Just clarify on this point.
Item 13.
Deeply.
Order. Nalage file. No. Itu file nalage. Itu dia. Or get an answer. Yes, 13. You are paying for the respondents. Okay, that matter. We'll not dismiss it. List again on Thursday. None appears for the parties on call. List again on 25/1/2020.
Item 14.
Yes, Mr. Mukesh.
My lord, of course, my lord, this is a very old matter. And my lord, if your lordship go into the affidavit filed by the respondents, they admitted my case. There was a selection. I was one of the selected candidates. They kept the matter pending on by taking the plea that there is no vacancy available, number one, and number two, there was no any approval accorded by the government. My whole contention, my lord, in support of my case was that you issued an advertisement inviting application from intending eligible candidates in respect of various districts. I belong to Nagaon district. I applied for the post of CO. The circle organizer under VDO, Village Defense Organization, under the jurisdiction administrative control of the SP. They, my lord, did not publish the select list. They admitted that fact. And later on, my lord, on 16/5/2013, approval was granted. And they made a proposal for appointment. And my lord, in terms of that approval, appointments were made in respect to other districts. But so far as the Nagaon is concerned, my lord, no any appointment. Therefore, in terms of that admission, that I am eligible because of being selected.
Where did you get that 2013 appointment part?
2013, my lord, up to 2013, they said there is no vacancy.
No. You said now
My lord.
that in 2013 approval was given and
Yes.
appointments were made. Where do you
Yes.
get that?
My lord, you will find it in their affidavit.
Yeah.
Affidavit by respondent number 3. Paragraph 16. I'm reading, my lord. With regard to the statement made in paragraph 14 of the writ petition, the department.
Respondent number?
Respondent number 4.
4,
Is the authority. And last portion of the said paragraph, my lord. 1, 2, 3, 4.
4. Okay. Para 16.
Para 16. At page, my lord, internal page 6. My lord. 1, 2, 3, 4, 5, 6.
What is the name of the author of the affidavit, Mr.
Authority, name of the authority is, my lord.
Okay. I got it.
You're going first title.
That with regard to the statements made in para 15.
16.
Lord,
you will find in the last 3 lines of paragraph 16. The government by so dated so to which approval was received from the government by number so dated.
I'm not getting it. I'm not getting it. My thing is, what is the name of the author?
Name of the authority is.
Who swear that affidavit?
Yes.
If it is respondent number 4,
Lina Dole.
It is from
Lina Dole.
Lina Dole. Lina Dole is different.
Is the deponent.
Wait. Lina Dole, I've seen it. Yes. This is, you are referring to para 16.
Para 16.
Okay.
And immediately after my lord, I made representation. I didn't get any response. Hence this writ petition. And respondent number.
No. Where is that contention of yours?
My lord.
That appointments were made in 2013.
Appointment was made in
2013. You just submitted.
They admitted.
That's what I'm looking into.
Yes. A proposal had already been made, submitted to the government for approval of appointment of 21 post of CO video lying vacant in the district, in defined district.
This is fresh appointment, Mr. Counsel.
Yes, a fresh appointment.
Fine.
They started making appointment.
Huh?
They started making
2001. So, my lord, basically a select list
Not
For a
even
year.
a select list. There was no vacancy. And these are future vacancies. Mr. Purkhaisto,
My lord.
these are future vacancies. It will not be covered by your 2001 select list.
No, my lord, once they, my lord, didn't cancel the select-creation, kept the matter pending.
You just
And
show me
you
a
are taking-
decision.
you are
You
taking the
just show
case.
me a decision
My lord,
that a select list prepared at a particular relevant point of time
my lord.
can be used to fill up future vacancies.
Yes, my lord, I'll show you, lordship.
Today,
Not today,
There is none, man.
not today.
then we are closing. 2013 matters, we are not.
But today I am not, my lord. The question was raised by your lordship for the first time.
Tomorrow morning.
Tomorrow, my lord, I will be out of station. Tomorrow and day after tomorrow, I will be out of station.
No, then Mr. Purkhaisto, we are
On Monday,
deciding.
lordship, keep
No,
the
we are
matter-
deciding the matter today.
keep the matter pending, no problem.
List this matter again on 29/1/2024 for delivery of orders. Before that, if you have anything, just show me.
My
If I don't get it, Mr. Purkhaisto,
My lord.
I'll pass orders.
Yes, yes. Lordship, pinpointed query is that, my lord, whether, kindly, my lord, repeat the.
Whether a selection process undertaken for a particular year
My lord,
can be used to fill up vacancies coming in the future.
yes. Basically, my lord,
And that too, when the selection is of 2001
my lord,
and the purported vacancy is of
my
2013.
lord,
12 years.
my lord. Notwithstanding the fact that, my lord, the kept the matter pending,
That they have admitted that there was no requirement
Vacancy.
because there was no vacancy.
my lord, if.
They made a mistake maybe in holding that recruitment.
My contention is that if in terms of that approval, you can make appointment on the basis of that 2012 approval to other district, why not, my lord,
No,
Nagaon district?
2001, those other districts were filled up. Only Nagaon was left out.
No, my lord, lordship, they say that in terms
Now,
of.
no.
this approval-
Now they are saying they'll go forward for a new selection process.
No,
Para 16. Read it. Anyway, on Monday,
Monday.
I'll give you some time, then
Yes.
we'll dictate the order.
Yes.
Okay.
My lord.
Supplementary 47, top of the list.
Great pleasure, Lordship.
Hmm.
Lordship, matter pertains to the termination of a contractual employee that employee is me, matter. I have been working as a block program manager under the NRSF.
You are appearing for?
He's on his way.
Yes, Mr. Dora. We heard this matter last year.
Yes, last time. My lord, the only limited ground was for the amount of compensation that can be paid. April 2011, I have not been paid salary since April.
You relied on some Supreme Court.
Yes,
Yes.
Lordship.
Yes, it's here.
Paragraph 5.
So what can I do for you? Tell me.
Lordship, April 2011 is in dispute. I say that I have been paid, I have not been paid, they say I have been paid. So we forego April 2011. 7/9/2011 is the termination order, date of the termination order. So for 4 months, from May, June, July, August, I may be given compensation 4 months paid, and notice pay was not given in my case. So 5 months, Lordship, if I get, I will be satisfied. I have no.
Mr. Gogoi.
Fine.
His now submission, he has given up everything. He's giving up everything. His only submission is that the incident is of some April
Yes, sir.
2011.
11.
And he continued to be hanging and you terminated him in 7/9/2011.
Yes, sir.
So for this period, he is asking for salaries, wages.
My lord.
You consider?
Including notice pay, my lord.
Yes.
You consider?
Yes, Lord. That on that line, it can.
They'll consider.
That will give rise to, and if a direct order is given.
No, direct order they will give. They will go to division bench. Then you will be in more expensive.
That will never be considered. So I know that.
They will. I'll bind them up.
No, sir, and the time frame may be given.
Okay. Mr. D. Dwara, learned counsel for the petitioner at the outset submits that the petitioner would be satisfied in the present proceedings if a direction is issued for consideration of his pay from
May 2011.
May 2011
So
Till-
August 2011, Lordship.
till 7/9/2011 on the date when he was terminated from his services.
Unless inclusive of notice pay may be kindly added. My lord.
Will not enlarge the issue. Let it be here. So, in view of the said submission, Mr. B. Gogoi has submitted. In view of the said submission of the learned counsel for the petitioner, Mr. B. Gogoi, learned counsel for the respondent, has submitted that the petitioner may be required to file an affidavit, file a representation before the mission director, right?
Yes.
It is still
Mission
NRM,
Director,
NRHM or NRM?
NHM now, National Health Mission only.
NHM,
Right.
before the mission director, National Health Mission, Assam, highlighting his grievances and bringing on record justifications for his said prayer. Also, the prayer of the petitioner is accepted and the writ petition stands disposed, accepted, and the petitioner is required, full stop, accepted, full stop. The petitioner is required to approach the managing director, mission director, NHM, by way of a representation, raising a grievance with regard to non-payment of his wages for the period May 2011 to 7/9/2011, along with justification for such claim. Also, the along with justification, the petitioner shall also furnish to the mission director NRHM a certified copy of this order along with his representation. Also, the mission director NHM, on receipt of such representation from the petition, along with a certified copy of this order, shall take into record the same, and after considering the matter in consultation with the contemporaneous records, and also upon affording an opportunity of hearing to the petitioner, shall come to a conclusion with regard to the claim made by the petitioner. Also, the conclusions that may be arrived at shall be communicated to the petitioner in the form of a speaking order, and therein all the issues raised by the petitioner, all the issues raised by the grievance petitioner must be considered. Full stop. The above exercise shall be initiated and completed within a period of 3 months from the date of receipt of a representation along with a certified copy of this order from the petitioner.
My lord,
With the
regarding
above
the
orders, the writ petition stands disposed.
challenge to the termination order, my lord, he has dropped that part, that may be reflected.
No, will not.
Because
We say only limited. Now the writ petition is gone, that is res judicata.
Yes,
Then
only for the salary part.
only salary. I have said at the limited, at the outset, he prayed, I did it.
My lord, in the meantime, I am now I am an advocate now. I am practicing at Morigaon, Lord.
Oh, very good. See, it's boon in disguise.
Born in this guys, Lord.
And like that, we had an occasion to have Mr. Dwara before us.
I am honored, Lord.
My lord, item number 45.
Motion, sir. Yes. Oh, Mr. Purkaisto, the motion, we will have it on second. Okay? Item number 22.
22.
List this matter again on 5/1/20. No. On 2/2/2024.
Lordship, second.
Second,
Lordship, Miss S. Truthia is appearing. I'll inform her.
we have
today.
been waiting for her. The whole day.
I'll,
Mr. Purkaisto has been kept here.
I'll
On the
ask her
next
to
day,
give
if we don't get, we will
My
have
lord.
the officer here.
My lord,
My lord.
item number
I'll get,
45.
I'll
Huh.
get the answer.
IIT, my lord. If you are
Yes, what to do today?
My lord, let it come tomorrow also.
Tomorrow, Mr. You will be waiting the whole day, there will be no use. Kundi na sa log khali, besi dur na sa. The old matters, 2013, those are taking some time. Can't deal with it very casually. 6th to be see.
My lord, can it be on day after, my lord, if it is
convenient to.
25th also we'll have it on first, if not inconvenient. First, just make a mention in the morning.
Yes.
We will accommodate you.
Item 45.
Both of you, I am requesting, just make a mention.
Yes.
We will accommodate.
Lordship, I beg your pardon, Lordship. Item number 46, Lordship, there is some urgency. See, hearing matters, though it should have been covered.
What is that issue?
Lordship, the issue is regarding special cat. We have found out 6 questions which are wrong. So only in respect of those questions, we have filed our affidavit in reply. The department has not filed any reply, any counter by saying that those questions, they are wrong questions and they can't allot marks in respect of those questions. That is the only issue. Our first grievance was that
Item number 46.
46.
List this matter again on.
My lord, in this matter, member secretary, state level empowered committee, that it is represented by, my lord, I think, Buddha.
Yes, we go.
His name is shown.
Not
Yes,
so,
his name
yeah,
is
in the first list.
In fact, Mr.
No,
Roy
it's
was
not
also
shown.
Roy
Not true.
Seva.
Roy, DK Roy was there.
DK
In
Roy
fact,
is
DK Roy was there.
No, here only GA Assam SC Education. 46, na?
Lordship.
46.
List again on 5.
Lordship, the issue is that BTAD has already issued that.
Okay, we will have it on 2. 2.
Lordship, the last date is on 2nd.
2nd, okay.
Yes. Can it be on
30th.
29, Lordship?
29, okay, fine, 29.
Lordship.
29/1/2024. We are not saying anything. You inform Mr. Gogoi before that.
Lordship.
And whether
List of
it's served the copy to be Gogoi or not.
That you all settle it. When it comes before me, I'll do what is required.
Can it be fixed? Can this matter be fixed at 2, Your Lordship?
Huh?
Again, can this matter be fixed at 2? Because otherwise it may not.
Make a mention in the morning. If there is any urgency
Lordship.
which has to be taken up,
Lordship.
make a mention.